May I please, your Lordship?
Yes.
Lordship, I beg to mention item number 1 of today's daily list, Lordship.
Yes. What is it?
Lordship, I'm take 2 weeks time, Lordship. If possible, Lord.
On behalf of Mr. Kolita,
Yes, Lordship.
what has happened to him?
Lordship,
What has happened to him,
Lordship, I have some personal difficulties.
madam? Okay. After a week,
After 2 weeks, Lord.
19 matters on a request made on behalf of Sri A. Kolita Learned Amicus Curie, appearing for the appellant. Matter is adjourned to be listed after 2 weeks.
Obliged.
May I please, Lordship?
Yes.
I'd like to mention an order matter, Lordship. Maybe come up on Friday. The matter was last discussed in the month of February, Lordship. Therefore, it is not listed.
What matter? Criminal appeal?
Appeal.
Orders for?
Order for Lordship, the record is received first, but the PP has not filed the objection.
In the IA?
Yes,
Okay. Okay, Friday.
obliged.
May I please, your Lordship?
Yes.
Lordship, I take to item number 7, Lordship.
Hmm.
Lordship, today, engaged counsel LR Madhu is out of station, Lordship. Kindly attend for the matter of today.
But 7 is connected with 8. 8, there is a amicus. Have you informed him? You have to inform the amicus. These are matters are connected. Mr. Bakchi's name has been shown as amicus. You inform him and come back. Okay? We'll accommodate you, but not without informing him. Yes.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 6 of the daily list. Lordship, AG is supposed to appear on this matter on behalf of NIA appellant, but he is busy in some other urgent matters. Maybe the matter speaks after 2 weeks.
Have you informed the other side?
Yes, Lordship.
Okay. On a request made on behalf of Sri D. Sekya, then Senior Counsel. List after 2 weeks.
Lordship, date may be fixed on 22nd.
2 weeks. You are seeking an adjournment.
Actually, after that, AG will be going abroad. If
2 weeks.
Kindly. Obliged.
Yes.
Make this as Lordship. Lordship, I beg to mention item number 2.
Yes.
Can it be taken up next week, madam?
Item number 2 is 19 matter. Why are you seeking time, Mr.
Madam, they make it
Chaudhary?
clear on behalf of Mr. Vidyari Chaudhary, madam. We'll do it next week, madam. I have informed the learned PP also, madam.
And there is response number 3.
His response number 3, we're looking for his number, madam, for number to inform him,
You
madam.
have to inform him.
Yes, madam.
Then you make a mention. You inform him first. And we, in fact, this is the first item. Okay, we'll accommodate. It was first, no?
Yes.
No, second.
Okay, 2. One has been adjourned.
One is attention.
Okay. Two and is Mr. Alim around? R3?
Ali will looking for his phone number, madam. We'll
Okay. Heard Sri M.A. Chaudhary, learned counsel for the appellant who prays for an adjournment. Also heard Miss So-and-so, learned APP. List after a week.
after a week, madam.
Yes. PB is there, otherwise paper book is there.
Paper book is there, Lordship.
Okay.
Ready for hearing.
Okay.
Deep privilege.
Please, Lord. On behalf of Mr. B. Bhagavati, amicus, can it be taken after some time, Lord?
Who is B. Bhagavati?
People Bhagavati, Lord. After some time, he'll do the case, Lord.
Oh.
Highly obliged.
May it please, your Lordship.
There was a delay condemnation or what?
No, your Lordship.
Why is it pending at this? Oh, okay, it's for hearing.
Hearing, your Lordship.
Okay.
I am for the husband, your Lordship. I had preferred a title to matrimonial, your Lordship. And the same was, Lordship, may kindly peruse page 27.
Just a minute, just a minute. Other side, Ms.
Madam.
Padgiri.
Madam.
Appellant is the first party,
Yes, sir.
husband.
Husband.
And against which
Against
order,
wife.
on an order of which court?
Principal Judge Family Court Borpeta, Your Lord.
Family court. Appellant first party. And suit for what? Dissolution?
Yes, Your Lord.
Under 13 what?
Under 13(1)(a) and 1(b) of the Hindu Marriage Act,
Cruelty
cruelty and desertion.
and desertion.
Yes.
Yes.
Your Lordship,
Marriage was solemnized when?
in the year 2014, Your Lordship.
Date.
3/3/2014.
Parties are Hindus?
Hindus, Your Lord.
Marriage as per Hindu rites
Hindu,
and
yes.
rituals. Okay, and any issues?
One child was born on 3/3/2015.
Son, daughter, what?
Son, Your Lord. And the lady, Your Lordship, has left the home on 12/10/2014,
Well,
prior to the birth of the son.
2014. She left the matrimonial home.
Yes, Your Lordship. On 12/10/2014. Thereafter, they have been living separately, Your Lord.
Okay.
Your Lordship, may kindly for a moment peruse the statement of the records, Your Lordship. I have adduced myself as a witness as well as my father, and she has deduced herself as a witness. Your Lordship, may kindly peruse
You had two witnesses, yourself and your father.
father. And she adduced to herself as a witness, Your Lordship, as DW1. May I read my affidavit on evidence, Your Lordship?
And there was only one DW.
Only one is. Oh, I'm sorry. Three, I'm sorry. Three, I'm sorry, Your Lord. Three. I'm sorry, Your Lord. Three.
Wife and who else? Mr. Padgiri?
My lord,
Who else?
my lord,
Wife
is the
Younger sister, Your Lord.
younger sister and father.
I apologize.
Okay. The suit has been dismissed. Suit has been dismissed.
Yes, Your Lord.
And you are aggrieved by that.
Yes, sir.
Okay.
Your Lordship, may kindly peruse the evidence on affidavit that I have filed, Your Lord.
Let us first have a cursory glance at your pleadings. Where is the petition?
Petition page,
Is it 17 or
14.
14?
Your Lord.
Yes.
May I read? The relevant portion starts from page 15. That the petitioner and the opposite party are husband and wife, respectively, having been married at village Baregaon of Korbuk under district Borpeta on 3/2014, according to Hindu rites and rituals, and the said marriage is still subsisting. That after the marriage, the opposite party went to her matrimonial home situated at Korbuk town, ward number 4, under Borpeta district, and started conjugal life with the petitioner. That the petitioner is a dentist doing private practice at Korbuk, and on the other hand, the opposite party is an additional assistant teacher contractual at Gornogor Girls High School, Secondary School, Korbuk. That after some days of marriage, the opposite party disclosed to the petitioner that she did not like to continue her conjugal life in her in-laws' house and insisted the petitioner to stay at a rented house. But the petitioner vehemently opposed her proposal for staying at a rented house, leaving his old aged parents. That after refusal of opposite proposal of opposite party, the opposite party gazetted negated the petitioner along with her in-laws, and the relationship between the petitioner and the opposite party had been deteriorated. That the opposite party during the staying at her matrimonial home always created a polluted atmosphere and always caused ill treatment to the petitioner and her in-laws and thus disturbed the mental peace of the petitioner and his parents. The behavior of the opposite party had been such as caused extreme mental distress and in consequences has been detrimental to the mind and health of the petitioner. That the opposite party had always treated the petitioner with cruelty as to cause reasonable apprehension of the mind of the petitioner. That the parents of the opposite party had also caused ill behavior to the petitioner and they were instigated their daughter to live separately in a rented house. That frequently the opposite party, without taking any permission to the petitioner and her in-law, left her matrimonial home and staying at her parents' house. And in such behaviors, it presumed that the opposite party was totally disinterested to stay at the matrimonial house. That since the marriage, the petitioner and his parents have been constantly living in worries, anxieties because of irritated, whimsical, distressing, and most abnormal human behavior pattern of opposite party and her family members. That lastly, on 12/10/2014 at about 4 p.m., the opposite party called her mother over telephone, and when the mother, along with her elder sister of the opposite party, namely Meenakshi Das, came to the house of the petitioner, and she left the matrimonial home with her mother and said elder sister without taking anything to the petitioner and her in-laws. That after 2 days from her departure, the petitioner came to know that the opposite party had lodged an FIR against the petitioner father-in-law, Salim Chandra Roy, mother-in-law Dipali Roy, and brother-in-law Bhaskar Roy with an allegation of torture. And after receiving the FIR, the OC Korbuk PS had registered a case by Korbuk PS case number 336/2014 under section 498A. 34 IPC. That accordingly, the police submitted charge sheet against the petitioner under section 498A IPC, and after completion of trial, the Lanet Judicial Magistrate First Class Corpeta in GR case number 6844/2014 had acquitted the accused person. Then in the month of February 2015, while the opposite party staying at the parents' house, she gave birth to a male child, but the opposite party did not inform of the birth of her child to the petitioner and her in-laws. Yet the case which was filed against the petitioner and his family members by the opposite party at Korbuk Police Station was not based on true facts, only to harass the petitioner and his family members, and after trial, the Lanet trial court had acquitted the petitioner. That the cruelty of the opposite party against the petitioner being a continuing affair during the stay of his matrimonial house, even after leaving her state house by filing an affair of false allegation, and as such, it is not possible to mention specifically the details date and time of cruelty. That since 12/12/2014, there is no any communication between the petitioner and the opposite party till date. That now the petitioner has realized that the matrimonial relationship with the opposite party has been broken, and in such situation, it would not be possible for the petitioner to continue his matrimonial relationship with the opposite party anymore, and for the peaceful coexistence of the parties, it is desired that the marriage tie between the parties be dissolved by a decree of divorce. It will not be possible for the petitioner to continue his conjugal life with the opposite party due to her unaccepted cruel behavior upon the petitioner and her in-laws. That the cause of action, I'm leaving that part, your lordship. So I had prayed that your honor would be pleased to dissolve the marriage tie between the parties by decree of divorce and pass such order or orders as your honor may deem fit and proper. To this case, file a written statement, your lordship. While denying any everything, your lordship may kindly peruse page 21. May I read, your lordship? Page 21. Written statement by the opposite party.
Yes.
I'm reading from paragraph 3. That the submission made in the application by the petitioner, such as after some days of marriage, the opposite party disclosed that she did not like to continue her conjugal life in her matrimonial house and insisted the petitioner to stay at a rented house, but the petitioner vehemently opposed her proposal. The opposite party gradually neglected the petitioner along with her in-laws. Relationship between the petitioner and the opposite party have been
That you can
Yes.
skip because that is only a verbatim reproduction, then
Yes,
a
sir.
denial.
Court.
Yes.
Paragraph 22, your lordship. 4, paragraph 4. That the entire case, the submissions, that the entire case is well-planned conspiracy of the petitioner and his family members to get rid of the opposite party somehow by leveling some false, imaginary, concocted, and false allegations. That the petitioner and his family members had a bad habit to sleep after midnight, as the opposite party was pregnant and health was not good, so she wanted to sleep at time but did not allow her. Then she page paragraph 7, your lordship. Then on 10/10/2014, the opposite party with due permission came to her parental house on account of puja and returned to her matrimonial home on 12/10/2024. But the petitioner and his family members did not allow her to enter home, and the petitioner assaulted the opposite party in the courtyard at the instigation of other family members and driven out. The helpless opposite party at about 8 p.m. attended Korbuk PS and her mother and lodged an FIR before the OC Korbuk police station. That after filing an FIR, an attempt was made to settle the matter amicably, and the opposite party was ready to withdraw the case, but the family members of the petitioner appeared with a local advocate with written withdrawal petition, where it was mentioned that the opposite party's mentally disturbed woman filed a false case. The opposite party denied to sign their withdrawal petition and after taking shelter at her parental house, that being a doctor, the petitioner does not apply his mind and decide himself. That the petitioner neither attended her parents' house nor inquired about his pregnant wife even over telephone. Even the petitioner repeatedly refused to receive her phone calls. That the petitioner neither took the opposite party to a doctor nor any expenditure for that. The petitioner and his family members did not provide any help for course. The opposite party had to do every household activities alone. Instead of treating the opposite party as wife, the petitioner treated her as a housemaid. After marriage, the petitioner, without any reason, completely stopped to communicate with the opposite party family members. He also strongly ordered the opposite party not to communicate. Besides, the petitioner did not take a single word if somehow he saw the opposite party family members. That even if the opposite party is staying 1 or 2 days in her parental home and returns, she saw that her father-in-law called in some relative, rebuked her badly, and also gave warning of divorce. That since the opposite party has a son, so thinking the future of her son, she wants to continue her conjugal life with the petitioner. The opposite party does not think of divorce anymore and never. So I'm stopping here, Your Lordship. Now, Your Lordship may kindly peruse the evidence, Your Lordship. The statement of PW1. I'm straight away going to the cross-examination. In the LCR, Your Lordship.
Page?
This is the it's in the LCR, Your Lordship. I'm not NFT.
Okay. You're referring to the evidence.
Evidence. The cross-examination of PW1, Digonto Roy, the present petitioner, Your Lordship.
Yes.
May I read it? We got married with each other on 3/3/2014. It was an arranged marriage. After marriage, we started our conjugal life and live as husband and wife in my parents' house. Respondent is a teacher and employed as a contractual basis. My parents and my brother is resided together in our house along with me. I am a dentist by profession and running my profession as a private practitioner at Horbrook and Borpeta Road. The house of the father of the respondent is situated about 3 kilometers away from my house. We live happily nearly about 2 months. Thereafter, marital dispute arose between me and the respondent. In spite of that, we lived together as husband and wife till October 2014. At the time of Durga Puja celebration, respondent went to visit her parents' house in the year 2014 and returned to my house on 12/10/2014. It is not a fact that when the respondent returned to our house on 12/10/2014, my parents and myself did not allow the respondent to enter into my house. Therefore, respondent went to Horbrook Police Station for lodging a criminal case against me. It is a fact that an FIR has been filed by the respondent against me and my family members, and I, along with my father, went to the police station, and in that police station, respondent and her father also present, and a discussion held between us about the amicable settlement of the dispute, and advocate Shantanu Chaudhary also present in that discussion. It is not a fact that the settlement was arrived between us, but before arriving settlement, I imposed some condition that respondent shall not visit her parents' house in her future, and she have to hand over her salary to my father's hand. It is not a fact that I did not allow the respondent to enter in my house. As such, respondent started to living with my parents. It is true that when the respondent resided in her parents' house, she was pregnant already, and I did not inquire about her health status as because the respondent filed a criminal case against us and also threatened us by the family members of the respondent. I know that there was a nursing home named Binapani Nursing Home at Borpeta Road. I did not know that my son was born at Binapani Nursing Home as because no one informed about that matter before me. However, after some time, someone informed us that a son was born to respondent. We went to the house of the respondent to inquire about my son after his birth, but the family members of the respondent did not allow us to enter into their house to see my son. I know Dr. Pores Kolita. It is not a fact that Pores Kolita informed me about the delivery of respondent and also informed the son was born to us. In the month of February 2015, our son was born, but I do not know the exact date of his birth. It is a fact that I do not mention in my divorce petition that I visited the house of the respondent to see my son after his birth, but the family of the respondent did not allow me to enter her house. It was also not mentioned in my evidence in affidavit that I went to the house of the respondent to inquire about my son, but the respondent and the family members did not allow me to enter into their house and to see my son. It is not a fact that respondent did not pressurize me to live separately and took a rented house for respondent and me. It is not a fact that my wife respondent did not neglect me and ill behave with me and created polluted atmosphere in our house. It is not a fact the parents of the respondent did not ill behave with me and also instigated the respondent to live separately. It is not a fact the respondent was interested to stay at my home. It is not affected on 12/10/2014 at 4 p.m. Respondent did not call her mother and sister, who after some time came to our house, and along with them, respondent went away from our house. It is not affected soon after marriage. My parents mentally tortured upon the respondent and forced her to do work as domestic servant. It is not affected I did not listen to my wife's respondent after our marriage in any matter. It is not affected my father wanted to took the passbook of respondent with him and he wanted to deposit the monthly salary of the respondent in his hand. It is not affected I am not entitled to get divorced for the reasons which I have shown in my divorce petition. Though the respondent wanted to continue our marital life, but it is not possible as because she has already harassed me by filing false case and caused mental torture on me during the period when she stayed with me in my house. It is not affected I am misguided by my father and my mother, and my father wanted to deposit all my income in his hand. I am not yet decided to take custody of my child at present. After observing the facts in circumstances near future, I will decide whether I will take the custody of my son or not. Then, Your Lordship, PW2, cross-examination of PW2, the father, Your Lordship, Dalim Chandra Roy.
Yes.
Respondent is my daughter-in-law. About 5 years ago, my son married the respondent as per Hindu rites and rituals. After marriage, both the parties started their conjugal life and lived as husband and wife. Respondent is a contractual teacher by profession. I do not know all and every matter of my son and daughter-in-law in their life. Respondent filed a criminal case against us at Korbuk Police Station, and when police called us to Korbuk Police Station accordingly, when I approached the OC to the police station, it was came to my knowledge that respondent alleged and labeled allegations that we ill-treated her and kept her starvation and also assaulted her. Both the parties wished to arrive into an amicable settlement. Accordingly, a settlement deed was prepared, but before it was done, the respondent did some conditions to us, which we agreed, but the family members of the
Just a
respondent—
minute, just a minute. একটু allegation double আছে নাকি? নাই চাগে না? খাবলৈ দিয়া নাই। Okay. Was there any allegation in the written statement that she was not given food
Yes, Your Lordship. Yes, alleged.
in the WS?
WS also. It was not given proper
Oh, there
food.
is a foundation of the time. Where is it?
Your Lordship may kindly peruse. Page 20. 23. Uh, definitely, no? 23.
Is it
7,
there?
Your Lordship. 23, 7. Paragraph 7.
Please
Yeah.
read.
That on 2010-2014, the opposite party with due permission came to our parental house on account of puja and returned to her matrimonial home. But the petitioner's family members did not allow her to enter home, and the petitioner assaulted the opposite party in the courtyard at the instigation of other family members and driven out. The helpless opposite party at about 8 p.m. attended Korbuk PS with her mother-in-law's FIR before the OCPS. After filing of an FIR, an attempt was made to settle the matter amicably, and the opposite party was already ready to withdraw the case, but the family was the petitioner appeared with the local advocate written withdrawal petition where it was mentioned that the opposite party is mentally
Not this, Mr. Deori. We are asking about the starvation thing,
disturbed.
that she was not given food. I don't find, we had a cursory glance, but we don't find that it's there. If it's there, kindly show us. Because there's a question in the cross-examination. There has to be a foundation.
Yes, Your Lordship. No, it was not there.
It's not there. You said yes.
No, I thought, Your Lordship, I'm sorry, I did this allegation.
Thinking is against you. You're thinking against yourself.
I apologize.
Some point which may be favorable to you. You're saying yes. Yes, then? Nine. One kora. Pudor kotha koi nahi.
Your Lordship, I'm reading from
Yes.
9 line, Your Lordship. 8 line, Your Lordship. 9 line, Your Lordship. Also, it was came to my knowledge that respondent alleged and level allegations that we ill-treated her and kept her starvation and also assaulted her. We both the parties wished to arrive into an amicable settlement. Accordingly, a settlement deed was prepared, but before it was done, the respondent gave some conditions to us, which we agreed. But the family members of the respondent, before arriving into an amicable settlement of the criminal case, they started to inquire about before OC and second officer that where they were competent to file another case against us. It is not a fact that on hearing about the facts, my son felt insulted and humiliated, and as such, he disagreed to compromise the matter with the respondent. I do not know whether the above mentioned fact was recorded in my evidence in affidavit or not. My daughter-in-law respondent always went out to attend her duty at 9:30 a.m. and return after school or period is over. There was no domestic servant in our house. I know the respondent get rupees 20,000 per month as salary. It is not a fact that I ever inquired about the salary of my daughter-in-law or demanded to deposit her passbook in my hand. It is not a fact that I myself and my family members mentally tortured upon the respondent even when she was resided in our house. It is not a fact that when the respondent, after visiting her parents' house, came to our house, then we did not allow her to enter into our house and also rebuke her using slang language. I do not know the place and time when the son of the respondent was born. I never went to the house of the respondent's parents to see my grandson. I am not willing to accept the respondent as my daughter-in-law in my house. Do I want to want the custody of the son of respondents, but my son is the best person to decide that matter. It is not a fact that petitioner is not entitled to get divorce decree for the cause mentioned in his divorce petition. It is not a fact that I demanded to deposit the income of my son in my hand. Now, Your Lordship, the defendant witness number 1. This is the wife. Vandana Das, Your Lordship. The cross-examination part. I left my matrimonial house since 4 years back. So, Your Lordship may kindly, she has admitted the fact that she has left. I tried to make contact with the plaintiff, but he refused. None of my family members made any contact with the plaintiff for settle our dispute as reunion. I filed a criminal case against the plaintiff and his parents under Section 498A IPC. In that case, court recorded my evidence along with my father. It is not a fact that in that proceeding under Section 498A IPC, I told before the police that though I lodged a complaint against my parents-in-laws and against my brother-in-law, but their name was recorded out of anger and due to misunderstanding. In that proceeding, plaintiff got acquitted, but against that judgment, I did not prefer any appeal before any high court. I receive a rupees 20,000 per month as a salary from my job. My husband plaintiff is a private practitioner. I cannot definitely say the exact income of my husband, but he earned not less than 2 lakh to 3 lakh per month. But I told the same amount as his office income on my assumption. It is a fact that I did not support my husband's plaintiff to give any portion to his earning to his father. The neighboring people knows our marital dispute. My father's house is situated 1 kilometer away from my husband's house. The parents of my husband and their younger son live jointly with my husband plaintiff in their house. Except my husband, my father-in-law and brother-in-law have their own earnings because my father-in-law is a retired teacher and got his pension monthly from the government, and also brother-in-law running 2 pharmacies. It is a fact that I did not mention about the earning of my father-in-law and my brother-in-law in my examination in chief or in my written statement. It is not a fact that when my son was born, I did not give any information to my husband and his family members. It is not a fact that as I want to stay in a rented house separately from my parent-in-laws, but my husband refused. As such, I left my matrimonial house at my own will. It is not a fact that after leaving my matrimonial house, I filed a false criminal case against my husband and on his family members. It is not a fact that I did not know the actual income of my husband plaintiff. It is not a fact that my husband plaintiff and his family members were insulted when they came to my parents' house. It is not a fact that soon after our marriage, I always created a polluted atmosphere in my matrimonial home. It is not a fact that I ill-treated my husband when we were living together at his house. It is not a fact that I neglected my duties as a daughter-in-law towards the parents of my husband and also neglected him. It is not a fact that I ever left my matrimonial house without the consent of plaintiff. It is not a fact that in spite of repeated persuasion of my husband, I did not return back to my matrimonial home to cohabit with my husband. As such, he forced to file his divorce petition against me. It is not a fact that I behave abnormally with my husband and always disregard him. As such, he forced to file his divorce petition against me. Now, Your Lordship, the next.
In the criminal case, it was a contested matter.
It was a contested matter, Your Lordship.
Have you annexed the judgment?
No, Your Lordship, but
Not as an exhibit.
No, Your Lordship, it is not an exhibit, but it is already admitted by her.
No. It's not a question of admitting. We know it's been acquitted. We wanted to know how was it being contested. See, lodging a criminal case at the impulse heat of a moment is another matter, and pursuing it diligently is another matter. Lodging and thereafter while conducting the attitude becomes apparent, whether you are serious with the case or whether your conduct shows that you are not so serious. So we wanted to have a look at the judgment. Our pleadings evidence may not constitute a case of cruelty to that extent which the Act wants. The other some part to separately sum the government into cruelty come into but lodging of the affair and pursuing that case Death may have an impact. So, আমি চাব খুজিছিলোঁ কেনেকুৱা বা how was it pursued?
I'm extremely sorry, Your Lordship. I do not have a copy, but I can read out the judgment with me.
Was it, obviously it was contested. He was
Yes.
cross-examined.
Yes, Your Lordship. May I read the judgment, Your Lordship?
Huh?
Uh, This prosecution case in brief is that on
How many pages?
Your Lordship, only 5 pages. I read out slowly, Your Lordship. I read only. The prosecution case in brief is that on 4/8/2014, the
Can you
complainant.
pass it over to us?
Yes,
We'll-
Lordship.
You can take it out from that compilation. I think it's separate. That deposed any evidence that a complainant did not want to stay in the husband's house and she came back to her mother's house. Mhm. Neighbor. It appeared to to the presence of the husband fire. And the 4, 5, 6 number. Investigated the case. এখানে যদি 161 হয়েছে out of anger, she had implicated her in-law out of anger. And then why were they pursuing the matter? বুজিলো আমাক চাইছে আহিছে সাক্ষীটোত মানে সাক্ষীটোতো হেৰি কৰি দিব পাৰিলে হয় ন সেইকাৰণে মই ক্লেৰিফাই কৰিব ঢিলা কৰি দিব পাৰে এইটো পুৰা ফুল ফৰৱাৰ্ডত মানে লাগি আছে বস্তু It was subsequently some further deposed that a complaint had not stated before in the accused had tortured her by bringing poor quality and she had complained. How old is the child?
He was born on 2015, your lordship, 9 years old.
9 years.
9-year-old. That is one of the concerns which you will have to address.
In my respectful submission, your lordship, the opposite party, she left the matrimonial home on her own sweet will. We had no communication with her, your lordship, after she left on 12/10/2014.
Now, her version is that she left for her paternal home on 10/10. There was a puja,
Yes, your lord.
and 12/10 she had come back.
Yes, your lord.
She was not allowed to enter the matrimonial
Yes,
house.
sir.
She was rather tortured, and 12/10 itself, she had lost the FIR,
Yes, your lord.
which resulted in the GR
Yes,
case,
sir.
where you have been acquitted.
Yes, your lord. And the other evidence also, your lordship, establishes the fact that from 12/10/2014, he has been living separately from me.
Do you have copy of the Ajahar? It was all 498 all heavy with register with. There may not be a case when it's not been in the context of demand for dowry. Any assault over. It will angle masala. That is an independent offense, not necessarily for supposed to bring in 498, there has to be a demand for dowry. But otherwise, it can't work. Medical was any medical conducted on her after lodging of the affair?
No.
Because she had alleged that she was assaulted
Yes, your lord.
on 12.
But the honorable court has acquitted me, your lordship.
No, that we know.
Yes.
And that from that, many things cannot be deciphered. You cannot assume anything.
Yes.
You have the evidence in the criminal case.
No, your lordship. Yes.
It is injury got a 9 into it. 4 and 9. PW1. In her cross with me. 2 mark with 2. Is the mother. Pulled her and pulled down her mobile. Misbehaved. Tried to assault.
What was the reason?
It was Visibly on further deposed that her in-laws and husband misbehaved her family members and that her mother-in-law tried to assault her mother with a chair. Tried to assault her mother with a chair. On 12. PW1 further deposed that her ornaments were in the custody of her mother-in-law and that the same was returned back to her when her husband intervened. PW1 had further deposed that the accused subjected her to cruelty by taunting her that furniture inferable for the deposed of this tree her away from the house. Yes.
BW. Your lordship may kindly say BW2. BW2, your lordship.
Last around 10 years, you were separately staying,
Yes.
separate.
Yes. From 12/10/2014, we've been living separately. Your lordship may kindly peruse.
Are you paying any alimony?
No, your lordship.
They have not filed any case
No,
for alimony.
no.
You are a salaried person.
Now regularized, assistant teacher of high school.
You are contesting this matter.
My lord, contested,
No, this here in this appeal you are contesting.
my lord.
No, we are still with Mr. Deori. What do you propose?
But still I am to hope, my lord, to reconcile the my lord, matter, my lord, reunion. Therefore, I oppose the divorce. But it is effect my lord, child also. My lord. He is the 9 years old. My lord.
See, there are two allegations, cruelty and desertion. Both are statutory grounds for divorce.
And-
First part, cruelty needs to be proved. Desertion, the requirement of proof is slightly different. Merely the fact of staying separately will not be enough. There has to be an intention on your part to desert, not to come back. Animals desertendi. What efforts did you take that after the particular date,
My lord, I categorically
12/10/2014,
categorically stated, my
and
lord,
from what is the conduct of yours from which one can come to a finding that you intend to come back?
but my lord, on 10, my lord, I with due permission, my lord, I take that, but
That was on 10th,
thereafter 12, my lord,
after 12th.
That 12, my lord, I stated in WS, my lord. Did not allow her to
That was on 12th.
12, my lord.
12th, that is your version. They said that you had gone with on your own suit will. After that, did you make any efforts from your family to reconcile and you come back to the family, to the
No.
matrimonial home?
No.
From where do you decipher that you had an intention to come back?
After that, my lord, because my lord,
See, custody of the child, welfare of the child is another aspect. We'll deal with it. But what about the aspect of the desertion?
the appellant adamant, my lord, regarding and filed a divorce petition, my lord.
No, see, when was the divorce petition instituted? Which year? It was in the year 2018,
2018 year old.
right?
Yes.
And the allegation of desertion is from October 2014. He had not filed immediately after 2 years. He filed it after 4 years.
But,
And in these 4 years, was there any attempt from your side or your family to reconcile the matter? You come back to the matrimonial home. Was there anything on record? Is there anything on record?
no.
Then how do you overcome the aspect of animals desertendi? How do you say that you do not have animals desertendi?
He has filed, my lord, divorce petition after acquittal, my lord. Continuously, my lord, and a lady, my lord, if my lord entered or my lord approach, my lord, he may
Mr.
harm, my lord.
Padgiri, simply
he may
saying,
harm.
making a statement, I am ready and willing to come back will not do. There has to be some materials from where your
I-
conduct would be apparent that you want to really come back to the matrimonial, save the family, save the marriage.
My lord,
Did you hold any discussion, the family members, to settle the matter from your side?
No, but
Conciliation effort was any.
সেইটোতো on the efforts of the court. তেওঁলোকে কিবা কৰিছিলে নেকি মা ৰাইজ মাতি আমি বস্তুটো কৰা নাই না। এইটো এপিলত। Okay.
Still really focus.
During the pendency of the appeal, was there any attempt for conciliation?
I have to take instructions, your lordship. In
No,
that
no.
regard,
Was there any attempt?
I'm
No,
actually,
on the instance of this court.
no, your lordship.
And 20 just নিয়ে কিবা এটা আছে নহয় section plus 28 নহয় কিবা এটা আছে নহয় এই যে হেৰি ট্ৰাই কৰিব লাগে যে $32. এখন হিন্দি में reject.
This honorable may attempt to call them personally.
नहीं এখন তো ওর আছে এখন তো আছে তোমার রেজিস্ট্রেশন Is there any provision in the Act of 55 regarding that there at any stage attempt for conciliation can be made at the instance of the court? Hmm. Court has the appeal of appeal is a continuation problem. Order 130.
Section 21, your lordship. It is subject to other provisions contained in this act.
21.
21. Subject to the other provisions contained in this act and to such rules as the High Court may make in this behalf, all proceedings under this act will be regulated as far as me by the Code of Civil Procedure 1908. So it may be done here, but in my
And how does it help? Then how, in the CPC, what do you have?
CPC. Your lordship, section 151 of the CPC It says nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such order as may be necessary for the ends of justice or to prevent abuse of the powers of the court.
That is the inherent power.
Inherent
No,
power.
no, no. Regarding attempt for conciliation. Yes, you have not read the Hindu Marriage Act. এটি ট্রিটাস এটা একটু ভালো বস্তু লিখতে ফ্যামিলি ম্যাটার কিন্তু এটা হয়নি সব একটা তোমার arbitration একটা দিচ্ছে এখন দিচ্ছে ম্যাক্সিমাম যে মানে it can be settled by way of negotiation or talk. Which section? The act is in your hand.
Yes, sir.
You can't find the section. Mr. Deka, which section? Which section? Twenty-eight, 23.
Uh, 13A, Your Lordship.
13A. What is 13A?
Oh, not paper, I'm sorry.
He is prompting something. What has he prompted?
23 decree in proceedings.
What is it?
This is decree in proceedings, Your Lordship. In any proceeding under this act, whether defendant or not, if the court is satisfied that any of the grounds for granting relief exists and the petitioner, except in cases where the relief is sought for by him on the grounds specified subclause A of subclause B or subclause C or clause 2 of subsection 5, is not in any way taking advantage of her own wrong or disability for the purpose of such relief. Where the ground of the petition is the ground specified in clause 1 of subsection 1 of section 13, the petitioner has not in any manner been necessary or connived or condoned the act or act complained of, or where the ground of the petition is cruelty, the petitioner has not in any manner condoned the cruelty. And when the divorce is sought on the ground of mutual consent, such consent has not been obtained by force, fraud, or undue influence. The petition under section 11 is not presented or proceeding in collusion with the respondent. And before proceeding to grant any relief under this act, it shall be the duty of the court in the first instance in every case where it is possible to do, consistently with the nature of the case, to make every endeavor to bring about a reconciliation between the parties. Yeah. Sorry.
23
And you referred to the CPC 151.
One.
But still there is a provision in the CPC, which my learned brother has pointed out. Which provision? Don't bring 151.
Yes.
It is too general a provision.
It's 89, Your Lordship.
89.
By settlement of disputes outside the court.
89 isn't there.
This is outside the court.
পিটির ম্যাটার না, ক্যান্সেলেশন করবে জানি, তার নাম হবো জানি এটা বাচ্চাদের নামে আমি তাতেও দিব পাৰিম বৰপেটাতো দিব পাৰিম ইয়াতে অহাটো মানে অহা যোৱা হেৰি আহিব ন
They really want to contest. They want to contest the land. If they're still, it will hurt.
স্কোপটো দেখা নাই অনলি ফৰ দ্য কেছ মানে কজ অফ দি চাইল্ড অকমান কিন্তু ইয়াতে দিয়াতকে ইয়াতে দিলে এটা কি ভাল হ'ব অলপ কষ্ট হ'ব যদি আহা কিন্তু ইয়াতে এফেক্টিভলি হ'ব তাতে কিন্তু নহ'ব Can you try for sitting?
Yes, Your Lord.
Huh?
I will.
Not because of anything else, only because of the cause of the child. Son is only 9-year-old. And if you like to have a sitting, maybe you can put him in camera. They can come to the,
Mediation center.
not mediation. We can have an in-camera proceeding. And if we think there are chances of reconciliation, then we can send them for mediation also. First, we want to interact with the parties. But here, okay. And this interaction will be without prejudice to your respective merits. Irrespective of what you argue or what we decide finally, without prejudice to any of those, we'll just out of the court, we'll have to try to have an interaction and see. Child is in which class?
Like class 3, madam. 9 years.
When can they come? Your client is a private dentist.
Yes, sir.
Private then.
You are a teacher.
Teacher.
It may be slightly difficult, not very difficult to come from Sorobhog to Guwahati, but one day at least they'll have to make an effort for greater good. Okay. When can they come? We'll do one thing. We'll fix a date as far convenient to the parties. You can have an interaction with your, are you in touch with your clients?
Yes, Your Lord.
You have a telephonic discussion and give a short date, maybe this weekend or next Monday.
No.
Okay, whichever is convenient. And have the son also with you. Okay. Becca. Third, Sri T. Deori, Learned Counsel for the appellant, as well as Sri K.R. Padgiri, Learned Counsel for the respondent. Full stop. After hearing at some length, we are of the view that an attempt may be made for an out-of-court settlement. Full stop. In furtherance of such attempt, comma, let the parties be present in person on the next date, where full stop, after in person for an interaction. Full stop. Further orders would be passed after such interaction. It is, however, made clear that the aforesaid attempt would be without prejudice to the respective merits of the contesting parties in the appeal. Yes, list on. Tell us after some time, okay? You have a telephonic call, it should not be inconvenient to your.
I have got my learned friend, your lordship, that whatever date is fitting for him, I will inform my client, he will.
But still then, have a talk.
Yes, yes,
Talk,
definitely.
go outside and come back immediately. Okay,
Oblige, your
but
lordship.
don't have a date which is too late.
Yes, sir.
We want to, this bench wants to, since we have heard for some time, we want to continue. and Pass orders. And make copies of this criminal case
Yes, your lordship.
and try to get the copies of the evidence in the criminal case.
Definitely. Def-
And on the next date, you need to tell us the provision of the CPC.
Yes, I will.
My landed pen is there.
Which one?
Yes, sir.
Item number 3.
Let's see.
You're Mr. Bhagavati? Yes. And one more matter, Mr. Bakshi was there. Where is Mr. Bakshi?
There.
You have informed him? He was there and sitting. Why didn't you inform him? Unnecessary, he would be waiting for the matter. Do you know him? He was sitting in the court. We thought that you had informed him. Try to inform him. We don't want counsel to unnecessarily wait for a matter. Okay.
The dead body buried, Rauta PS was informed of the matter. Accordingly, police investigated the matter and nabbed the accused. It is ever paid to swear. So, my lord, the incident is of dated 21/2016, when the Dimala went missing, my lord. And 26 was the date when missing Azhar was lost. And later, my lord, 29/1, after about 9 days, my lord, this Azhar was lost.
And this is the formal Jahar at a later point of time, 29/1.
Yes, my lord.
Prior to that, police has already sprung into action and had nabbed him. Isn't it?
Prior to that, my lord, police questioned my lord.
No,
VC
no, no.
Ram.
Accordingly, police investigated the matter and nabbed the accused. Second last line. This is Jahar has been lost after he was taken into custody. There has to be another GD entry.
But for lordship, it is at page 165.
Yes,
Date is of 28/1.
20th.
Doesn't matter. This
Yes.
is 29/1 is this Jahar.
Yes.
And this is
Date
the
is of 28/1.
28/1. That means the earlier day,
Yes.
prior date,
Yes,
he was already nabbed.
yes.
He was my lord, questioned, my lord, because he was.
No, no.
at the-
Accordingly, police investigated and the matter and nabbed the accused. That is the statement made in the Jahar lost on 29/1. That means he was already taken into custody.
But actually, it was my lord, from the later statement, your lordship find that he was actually, my lord, after lodging of the FIR on 29/1,
Yes.
based on some extrajudicial confession made to villagers. And under what circumstances this extrajudicial was made, my
No,
lord?
no. We are not on the conviction. We are on the date when he was taken into custody.
At 8:45 on 28/1. Page
28.
166.
It is prior to lodging of this
Yes.
formal Jahar.
20th he was taken into custody.
Yes.
So this the FIR was registered under section 302 and 201.
And in this Jahar itself, he says that on 26/1/16,
Yes,
Rota PS was informed about the incident. That was the missing Jahar.
missing, my lord. Because until that date, my lord, nothing has happened, my lord. Where she is, my lord. And it was on suspicious, my lord. Later as public became suspicious, the Rishiram, they question, because they had some sort of, my lord, love affair. Love affair was there admittedly, so he was questioned, my lord. But The FIR was lodged based on the GD entry 28-1 when a body was, my lord, when somebody informed extrajudicial confession was made. Basically to my lord PW 14, my lord. Vikram Chetri, my who is stated to be the friend of the appellant. Now, if I lordship take your lordship to the witnesses, now before coming to the witness, my lord, some Gurkha student union was there, my lord. And that student organization was taking the initiative to my lord, disclose the extrajudicial confession, like my lord PW4, my lord. So this PW4, then 6, PW8, PW10, PW11, they have taken the Vikram Sethi, PW14, who stated that accuses his friend has told under their custody. So my submission is that there is a line of inducement, threat, fear, section 24 of the Evidence Act.
No,
Confession.
extrajudicial confession is otherwise also a weak piece of evidence.
Yes.
That cannot be the sole
Sole basis.
basis for a conviction. We'll deal with that. You
Yes.
continue.
Now, if your lordship, I will start with PW1, page 8. He is the
Jit Bahadur.
yes, Jit Bahadur Roy, my lord. I am the informant in this case. I know accused Rishi Ram Sharma, who is present here. This is Bimala Rai, was my younger sister. The incident took place around 10 p.m. on 21/2016, that is on 21. The house of my paternal uncle Surya Bahadur Rai is adjacent to our house. My younger sister Bimala used to study in one of the rooms of my paternal uncle's house and sleep in the later house at night. After having meal on the night of the occurrence, Bimala went to the house of said paternal uncle to sleep there for the night. That day she was at paternal uncle. On the day of occurrence, as my married younger sister and her husband came to our house, I went to sleep in the house of my paternal uncle. Around 10:30 p.m., Bimala went outside the house to defecate. But since she did not return for a long period of time, my paternal uncle woke me up. My paternal aunt searched for Bimala outside the house, but did not find her. My paternal uncle and I went out in search of Bimala, but we could not find her anywhere. The house of the accused is situated at a place some 20-25 meters away from our house. I have known since 2 years prior to the incident that there has been a love affair, that is my word, between the accused and Bimala. When I could not find Bimala, I went to the house of the accused and called him from the outside. Then the accused responded from inside the house, but did not come out. Usually electric light is kept turned on at the veranda of the house of the accused, but that day light was not kept switched on. When I could not find my younger sister Bimala, I informed my own maternal uncle Joybir Subba, Gurkha student, all Gurkha, Assam Gurkha Student Union, that is Student Union, about it. Being unable to find Bimala, we informed the police station. Later, I lodged a written answer with the PS. Exhibit 1 is the FIR and Exhibit 1 is so and so. During investigation, the police seized one Nokia mobile handset and one Airtel SIM card from the house of my paternal uncle Surya Bahadur Roy. I put my signature in the seizure list. Exhibit 2 is that seizure list. As we became suspicious, next page, of the accused, I lost the Azahar. Exhibit 1, I came to know from Vikram Sethi Mehta, PW 40, that after killing Bimola, the accused had called him, Vikram, to bury her dead body. And that gap period between conversation between Vikram is around 8 days, 8 to 9 days. And he suppressed that much, we told. Vikram Sethi Mehta did not disclose immediately that after killing Bimola, the accused had killed him, Vikram, to bury her. On being shown by the accused, the dead body was recovered from the place where it had been kept buried. The magistrate arrived and held inquest on the dead body. The police also came there. I was also present at the place where the inquest was held. Exhibit 3 is the inquest report. Exhibit so-and-so, Exhibit 3(1) is by signature. Inquest was held after the dead body was exhumed. By the cross-examination. When he went in search of Bimola, we found the accused in his house itself. He was there. It is not a fact that I did not tell the police that on the night of occurrence, the light at the veranda of the accused was not switched on. Now this, my lord, when we gave Vikram a slap, my lord, this is the line. When we gave Vikram a slap, he told us that the accused person had informed him over phone that he had killed Bimola and that the accused had sought help from Vikram in burying the dead body. So this is the, my lord, line that when he had given under what circumstances, that is not proof, my lord. Vikram came to the house of the accused around 2 p.m. Kindly note the date, my lord, on 21/1/2016. An FIR was lodged on 28, my lord. I saw it. I did not hear their conversation. The accused was present in his house from 21/2016 to 29, my lord. So he was there, my lord, at the house. Although in the FIR it was stated that napped, my lord. The public did not beat the accused. It is not a fact that it is a false that the dead body was recovered upon the saying being shown by the accused. It is not a fact the accused is not involved in the incident. It is not a fact that since we had a dispute with the accused or earlier I had adduced false evidence against him. So Vikram, my lord, was in the custody of Jeet Bahadur Roy, my lord, when these things has happened. Now next, your lordship will, may I take your lordship to PW2? PW2 is, my lord, Forgeswar Bosumatari. And he is a village, government village headman, my lord. He was only present at the time of exhume of the dead body, my lord. I have been working as government Gaon Buddha since 2002. I know Rishiram Sharma, who is present here. He hails from my lord. I know informant Jeet Bahadur Roy. This is Bimala Rai, was their younger sister of the informant. I heard that there has been a love affair between the accused and deceased Bimala since 2 years back. The police and the magistrate came to the place of occurrence, and the dead body of Bimala was exhumed from the place where it had been kept buried. So I also went to that place along with the public. The magistrate held the inquest on the dead body. I put my signature and so and so, madam. Next is when the police found a pair of shoes lying at the place of occurrence, they seized the same. So he was the witness where body was found. PW3, Krishna Bahadur Sethi, page 14. I know informant Jeet Bahadur Rai. I know victim Bimala Rai. My house is situated at a distance of 500 meters from the house of victim Bimala Rai. I know accused Rishiram Sharma, who is present in the dock today. The incident took place in the month of January 2016. On 29/1/2016, on being led and shown by the accused, police recovered the dead body of the victim, Vimala Rai, at number 3 Dhansiri in the paddy field. The place where from the dead body was recovered by the police, it was a damp place, Doloni. I, along with other villagers, were also present at the time of recovery of dead body. At about 500 people gathered there at that time. The dead body was disinterred from the place where it was buried. Police took the dead body for post-mortem examination. Police recovered a pair of shoes from the place of occurrence. The step. So this is PW3. PW4 is my lord Joy B. Limbu. Page 15. I know accused person who is present in the dock today. I also know Jeet Bahadur Rai. I knew victim Bimala Rai. The occurrence took place on 21/1/2016. On 21/1/2016, informant Jeet Bahadur Rai came to my house and informed me that his sister Bimala Rai went missing from previous day. I came to know from Jeet Bahadur Rai that his sister had affair with the accused person around 2 years ago. On the next day, I, along with others, went to the police station and informed the police about the missing of the victim Bimala Rai. Now, your lordship will see on 26/1/2016, that is the date, police met me at main stock of Dhonsiri and informed me that accused was having communication with the victim till the date of missing. Police asked me to accompany them to the house of the accused. Accused told the police that he used to talk with the victim over phone, but denied having any connection with the missing of the victim. Police took the accused person to the police station for making some inquiry. I went to police station on 29/1. 29/1 only he went. When police told me that Vikram Setri may give some information regarding the occurrence. Accordingly, police gave me the phone number of the Vikram Setri and asked me to contact with him over phone. And accordingly, I made contact over phone to Vikram Setri and asked him to meet me at Rota, but he expressed his inability to come at that time because of his other domestic vicissitudes. I, along with Jeet Bahadur Setri, went to the house of Vikram Setri at Rangapani. On being inquired, Vikram Setri told us that on 21/1/16, accused Rishira made a contact with him over phone at about 10 a.m. and asked him to visit his place. The date of my lord inquiry was 21/1. He know Vikram Setri. Accordingly, Vikram Setri went to the house of accused and met him at about 1:30 p.m. Rishiram Sharma asked him for some help. Next page. Because Setri told us that Rishiram Sharma disclosed before him that he had killed the victim Bimala Rai and sought his help to get the dead body buried. Vikram Setri, out of fear, refused to do it and left the place. I then took Vikram Setri to our village and kept him in an isolated, secure
This
place.
page 15, last word should be Vikram or Vikas.
Because it should be Vikram. my lord.
Vikram, I think.
Yes. typo. Third line I'm reading, madam, page 16. I then took Bikram Setri to our village and kept him in an isolated, secure place. We informed the matter to police also. I, along with others, went to the house of accused person. Village people already gathered there. Accused confessed before us and others that he killed Bimala Rai and kept her dead body buried in field. That is extrajudicial. The place is like a Pitani Doloni, Marcy land. Accused showed us the place in which he committed the murder and buried the dead body. It was around 9:30 p.m. In the light of torch, accused showed us the place. In the meantime, police came to the place of occurrence. So before police came, he had shown the as per the email of PW. He handed over the accused to the police. On the next day, around at about 10 a.m., executive magistrate along with police came to the place of occurrence. I was also present in the place of occurrence. Police got the dead body disinterred and sent it for post-mortem examination. So accused told us that he strangulated the victim. During investigation, police produced me before the magistrate and accordingly, magistrate recorded my statement under 164 CRPC. Exhibit 4 is statement recorded by magistrate. Police seized one Nokia mobile handset so and so from the possession of accused Rishi Ram Sharma in our presence. Exhibit 5 is the seizure list so and so. Police also seized one Nokia mobile handset and one SIM card bearing number so and so from the house of Surya Bahadur Roy. In our presence, Exhibit 2 is the seizure list. Police also seized one Intex mobile handset along with two SIM cards from the possession of Bikram Sethi. I was also present at the time of seizure. Exhibit 6 is the seizure list. Exhibit 6.1 is my signature. During investigation, police also seized one mobile handset and one SIM card bearing so and so from the possession of Miss Pooja Rava. Exhibit 7 is a seizure list. Pooja Rava is one of the friend of that Bimala Amai. Crossed by defense. House of the accused and house of the victim are adjacent with a common boundary. Accused was not absconding. I did not see when Bikram Setri visited the house of accused person. I cannot remember the telephone number of the victim. I do not know the phone number of accused person and also Bikram Setri. The place in which the dead body was found buried is at a distance of half kilometer from the house of the accused. It is not a fact that I did not state to police. The accused told us that he strangulated the victim. While confessing the guilt by the accused, his confession was not recorded through mobile, etc. It is not that the accused is not involved in the occurrence. So next is PW5, Gopal Kumar Setri. So page 18. I know accused Rishi Ram Sharma. He is present in the dock today. The incident occurred about 5 to 6 months ago. For last 5 years, I have been the BDP secretary of village number 3 Dhansiri. At the material time in the evening at about 6 p.m., I was ready for drawing milk of my cows at my residence. At that time, Tegh Bahadur Setri came to my house and asked me to confine accused Rishi Ram Sharma as because accused had committed some offense. I, along with Tegh Bahadur, then came to the house of the accused person. Already, some other people also gathered in the house of the accused. all of us confined accused. So he was under the my lord, custody of, already in the custody of some villager. So what sort of my lord portion or there is a inducement at his house? On being inquired, accused told us that he killed Bimala Rai and buried the dead body. Accused then led us to the place where he buried the dead body of Bimala Rai after killing her. I then immediately informed the matter to police. Police came and arrested the accused person. It was then 7:38 p.m. We, along with police and SSB personnel, were guarding the dead body for the night. In the morning, so next day, my lord, executive magistrate came. Another police officer came to the place of occurrence and disinterred the dead body of deceased Bimala Rai. We identified dead body of deceased Bimala Rai. A cross-examination. In the daytime, people of the locality take their cows for grazing to the nearby place where from the dead body was recovered. Accused is a good student. He passed SLC obtaining first division. And for obtaining first division, he was awarded a laptop by government. He is now a degree course student. It is not a fact the accused is not involved in the occurrence of murder of Bimala Rai. So the place from where it was recovered, is the open grazing land. So everybody used to go daily village for plowing. It's not that, my lord, something discovered. Page 19 is PW6. Mr. Sri Maniraj Setri. I know accused Rishiram Sharma. I know informant Jeet Bahadur Rai. The incident occurred about 6 to 7 months ago. For last 2 years, I have been holding the post of General Secretary of Gurkha Student Union of Rauta. I, being the Secretary of Gurkha Student Union informant, Jeet Bahadur Rai informed me that his sister went missing. Then Jeet Bahadur Rai informed the matter to Rauta PS. I was also present with Jeet Bahadur Rai along with other persons. Around 1 week thereafter, I came to know that dead body of victim Bimala Rai has been recovered. While the dead body was being recovered, I was also present at that place. The dead body was in buried condition and it was disinterred in presence of the police, magistrate and other people. As dictated by Jeet Bahadur Rai, I wrote the FIR. Crossed by defense, I do not know whether accused confessed his guilt.
He is not very material. He is only the script.
Script,
uh,
Scribe.
scribe.
Yes. PW7, my lord. Tegh Bahadur Lama. I know accused Rishiram Sharma. I know informant Jeet Bahadur Roy. The incident occurred about 1 year ago. My house is situated nearby the house of the accused, intervened by a dong, natural drain. One day morning, informant Jeet Bahadur Roy told me that his sister was missing from previous day. Jeet Bahadur Roy was making search to find out his sister Bimala Rai, victim. Police came to our locality and asked us to trace out victim, Bimala Rai. Police took the accused to police station for interrogation, and after 1 day, he was released by police. 8 to 9 days thereafter, I heard halla in the house of the accused Rishiram Sharma. Then I came to his house and saw a gathering of 40-50 people in the house of the accused. Already there were, my lord, 40-50 people. It was around 6:30 to 7 p.m. Accused disclosed before those people in my presence that he killed victim Bimala Rai and buried the dead body near a field. Those people means, my lord, which are the people not defined? Because there are many villagers. So, cross by defense is initially accused did not confess his guilt. He remained all along in the locality prior to his arrest since the day of missing of the victim. When the accused confessed his guilt, there were 40-50%. The place where the dead body was found buried is a grazing place. Generally, people came to that place for grazing of their cattle, etc. At the time when dead body was disinterred, I was not present. That's because I was at market at that time. It's not a fact the accused is not involved in that. So next is PW8, page 21. Mon Bahadur Rai. I know accused Rishiram Sharma. I also know informant. But his statement was not recorded, my lord. This person, my lord. 161 statement was not recorded. PW8. So I'll read then, my lord. I know accused Rishiram Sharma. I also know informant Jeet Bahadur Roy. Accused hails from my same village. The incident occurred about 1 year ago. I came to know from our village people that victim Bimala Rai went missing. These people were making search to trace out Bimala Rai. The people suspected the accused to have killed Bimala Rai, and accordingly they had asked accused person to give information about the victim. Accused then admitted to have killed Bimala Rai, and he led the people to the place where he kept the dead body of the victim buried. I also accompanied a group of people to the place of occurrence. The police was informed and police came to the place of occurrence. For the whole night, police was in guard of the place of occurrence. On the next morning, magistrate came and on being shown by the accused, dead body of the victim was disinterred. At that time, I was also present here. Police obtained my signature on a paper. Now, in cross, my lord, he has stated, my lord, I do not know for what the police obtained my signature. Police did not record my statement. So his statement was not recorded. Then PW9 is Mr. C. Hari Yogi. I know accused Rishiram Sharma. I also know informant Jeet Bahadur Rai. I also know the victim Bimala Rai. The incident occurred about 1 year ago. One day ahead of occurrence, Sanjeev Khatoria informed me over phone to go to the house of accused Rishiram Sharma. Accordingly, I went to the house of accused Rishiram Sharma and saw that village people gathered at the house of the accused. My colleague teacher reached the house of the accused within half hour. The people gathered in the house of the accused asked about the missing of Bimala Rai. The accused led the village people near the bank of the river Dhansiri. I also accompanied the village people. Accused has shown a place and said that Bimala Rai was in that place. Thereafter, police and administrative officer came to the place. Thereafter, only the police came. After showing the place to the villager, police arrested the accused. I heard that police recovered the dead body of Bimala Rai on the next day, my lord. Not immediately, but on the next day, who was buried in that field. I also present when the dead body of Bimala Rai was disinterred from the field. Cross-examination. Many people gathered in the house of Rishiram before I reached. So I did not hear if the accused said anything before the village people. On the first day when I went to the place of occurrence, I did not see Bimala Rai. I have no personal knowledge how Bimala Rai died. PW10, next page, my lord. Sri Sanjeev Khatiora. I know accused Rishi Ram Sharma. I also know informant Jeet Bahadur Rai. I also know the victim Bimala Rai. The incident occurred about 1 year ago. Jeet Bahadur Rai informed me over phone on 21/2016 that his sister Bimala Rai was missing from their house. On the next day, that is on 21/1/2016, I, along with Joybir Limbu and Jeet Bahadur Rai, went to Rauta PS. Police told me that accused made contact with deceased Bimala Rai over phone. Prior to occurrence, we know that accused and Bimala had love affairs. After returning from the police station, we all went to the house of accused. On being asked as to whether he had any information about Bimala Rai, he replied that he does not know anything. So he did not say that he confessed. Accused confessed before us that he made contact with the deceased, but he does not know where she had gone. After 2 days, police informed us that accused made contact with his friend Vikram Sethi. That is PW14. The villagers informed us that accused friend Vikram Sethi came to the house of accused Rishiram Sharma on 21/1/2016. This is the relevant date, 21. I, along with Joybur Limbu, Sakra Gautam, Jeet Bahadur Rai, Ram Sethi, Manoj Rai, these are all Gurkha Student Union, madam, made search of Bimala Rai. We suspected that accused might have taken Bimala Rai. We all went to the house of accused friend, Vikram Sethi. On being asked, he said that accused Rishiram told him that he killed Bimala Rai and buried the dead body. We returned to Rauta along with his friend Vikram Sethi and went to the house of accused. So Vikram Sethi was at that time in the custody of the villagers, madam. This Gurkha Student Union.
Vikram,
Yes, ma'am. Because it stated on being asked, he said accused Rishiram told him that he killed Bimala Rai and buried the dead body. We returned out to Rauta along with his friend, madam. Along with his friend.
so why was Vikram arrested?
Vikram not arrested, madam. Vikram was taken by those village people, this group, along into their custody. And they took the Vikram Sethi from Rauta, from the place Rauta to another place. So when Vikram Sethi made some extrajudicial confession, he was in the custody of all this Gurkha Student Union, madam. Next line, madam. We returned to Rauta along with his friend Vikram Sethi and went to the house of accused. So this Gurkha student and Vikram Sethi was taken and went to the house of the accused. Then we asked Rishiram. On being asked, Rishiram confessed before me. Before me means Sanjeev Khatiora and Joybur Limbu, Chakra Gautam, Jeet Bahadur Rai, that accused called Bimala Rai, killed her, and buried in a field situated western side of house of accused. Accused led us to the place where he buried the dead body of Bimala Rai. We went with him. Accused has shown the place where he buried the dead body. Again, we asked how he killed Bimala Rai. The accused told us that he killed Bimala Rai by pressing neck with gamucha. Thereafter, I rang. Only thereafter, only, my lord, they informed the police. Everything they have done it, my lord. Thereafter, I rang to Rauta police station over phone and informed what the accused has stated before us. Police came to the place where the dead body was buried at about 8 p.m. Police has guarded the place. So on the next day, police disinterred the dead body in presence of magistrate. The accused person showed the place to the police where the dead body was buried. Well, this is not discovery matter. Section 27, it is hit by section 27. Already place has been known to the person. So later on, my lord, accused person showed the place to the police. There is no discovery, my lord. So that portion I will argue, my lord.
No. How are you making this submission? Accused led us to the place where he had buried the dead body,
Yes, ma'am.
leading to discovery at page 23.
Place,
23,
yes, ma'am.
fifth line from the bottom.
Yes.
And this has been consistently stated.
Accused led us to the place where he buried the dead body of
Vimala.
Vimala Rai.
Yes. We went with him.
We went with him. Accused has shown the place where he had buried the dead body. Again, we asked how he killed Vimala Rai. Accused told us that he killed Vimala Rai by pressing nearby Kamusta. So
Yes.
he is basically, my lord, distinctly, this fact is distinctly related to only recovery of the dead body, man. Not,
Yes.
it cannot lead to the second part, my lord. How he was killed, So much of the information distinctly related to the discovery. That much only is admissible, my lord. Section 27, my lord. Section 27, my lord.
Yes.
How
Should
much?
be the custody. You mean to say?
Yes.
Please read.
Section 27 of Evidence Act, how much of information received from accused may be proved. Provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense, in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly, it should be without any doubt and clearly, to the fact thereby discovered, may be proved.
No. 27 is an exception to 25. This is सब कथा बोले admissible होगा, but if it leads to discovery, it can that much of it कथा नहीं. It nothing to do with confession made before the police. It is normal evidence से रहेगा. 27 क्यों होगा? 27 नहीं लगेगा. No, 27 is only a special case. Yes. That's only because they made before police not admissible. I don't know if it leads to discovery. Not in custody of the police.
So that
Now,
statement.
is it necessary to invoke 27?
Yes,
You are trying to make out a case that 27 is not applicable.
Yes.
Is it really necessary to invoke 27?
Yes, ma'am.
Why? 27 is an exception. That you make a confession before the police, it is not admissible. But those part would be admissible if it leads to a discovery. It is an exception to 25. Now here we are not neither in 25 nor in 27. He led some other persons. These will come as normal evidence. We'll examine this evidence,
Yeah.
whether it's the veracity of it will examine.
Yes, because
Those witnesses have been put to cross-examination. We'll
Yes.
examine that.
then may I read the cross by defense, page 24. Before recovery of the dead body, on being inquired, accused Rishiram denied the commission of offense by him. That is the thing, ma'am. I did not see as to whether Vikram Setri stayed at the house of accused on the relevant day. Since 21/1/2016, to 28/1/2016. This is the period, my lord. Vikram Sethi did not divulge about the occurrence to anyone, my lord. There were 10/12 persons went to the house of Vikram Sethi. When we inquired Rishiram about the matter, about 22/25% were present. From 21/2016 to 28/1/2016, Rishiram was present at his house. The people used to dress in the field where dead body was buried. I do not remember as to whether I stated before the police that Rishiram told me that he had made contact with Bimala Rai. It is not a fact that I did not state before the police that Rishiram confessed before us that he killed Bimala Rai by pressing her neck. Kamusa. It is not a fact that accused Rishiram is not involved in the commission of murder. It is not a fact that Bimala Rai went to field and fell down. As a result, he died. So what I am saying, my lord, here, that Vikram Sethi, my lord, is not consistently, my lord, at the same time or spontaneously have not informed. And he remained, my lord, suppressed there 21 to 28/16, that period, my lord. Around 8 to 9 days, my lord, he has not informed, my lord. So that section 6 of the Evidence Act also says, my lord,
Register.
yes, ma'am. That if happens to be, my lord, continuous, spontaneous, may I read it just, my lord? Relevancy of facts forming part of same transaction. Facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different time and place. So it has to be immediate, my lord, spontaneous and consistent, my lord.
See, your suggestion in the last line is not that somebody else had committed the offense.
Okay.
Last suggestion you see, it is not a fact that Bimola Rai went to the field and fell down, and as a result, she died.
My lord, page 24, my lord.
24, last
Last
line.
line.
Last line. It is not a very accused, this time is not
See,
important.
you tried to develop a case that Bikram Chetri had not divulged for around 7 days. But last line you say that he fell down.
It is not a fair. Bimala went to field and fell down. As a result, he died.
After her death, what happened? Automatically she had gone to that Pitoni, dead body.
It's not a fact that Bimala went to field and fell down. No, my lord, the part of my argument is 2 sections he was convicted, my lord, under section 30 and 201. So I am basically arguing on 302. 302, there is, my lord, if it is doubtful, my lord, whether he has committed, then that part will not go, my lord. But 202, 201 is this portion, my lord, regarding, my lord, the body that was found, my 201. 201 is that, my lord, exact word I forgot.
Concealing.
What's-
Concealing.
Yes, yes. So that portion perhaps is there, but so far the 302, my lord, that has not been proved by prosecution, my lord. Because
Confessional statement.
confessional statement has been recorded, my lord. That is the thing.
Oh, confession is there.
Yes,
Judicial.
if your lordship will come directly to that, then
That magistrate has been examined.
yes, my lord.
That was done by giving the due process.
Yes, the process. And that is
Time for reflection.
everything, my lord.
No
and-
police.
But confession statement is, my lord, exculpatory, my lord, in the sense that he has not he has stated that he has not killed her.
Let us see.
That is the
Page
thing.
140.
Page 145, madam. And that has been exhibited by prosecution. So, my lord, one thing, my lord, there is two confession. One is judicial confession and other is extrajudicial.
Yeah, let us see the judicial confession.
Yes, page 145, madam. Recorded under 164.
Hmm.
May I read it, madam? The accused named Rishiram Sharma is brought before me on 2/2/2016. Kindly note, my lord, 2nd of February by Govinda Nath at place chamber at about 1:30 p.m. to have his confessional statement recorded. I have ascertained that the alleged offense punishable under section 302/201 IPC was committed at place number 3 Dhonsari on 21/2016 at about 10 p.m. I have asked the accused in detail relating to his detention after arrest, and he stated that he was arrested at number 3 Dhonsari at about 8 a.m. and detained at place of detention, police station, for about 24 hours from 8:10 p.m. to 4 p.m. before being brought to court. Accused should be asked whether she got any injury or marks and so and so. So these questions were put to page 146. Did you receive any injury in your body? I sustained injury on my head. Bimala hacked me by means of a kukri. My observation, I have not seen any cut mark or forehead of accused. Then my lordship will kindly see below. What is your age? 20 years. Whether you married and I am not married. What is your occupation and what is your monthly income? I am a student of BA third year. Next page, whether your monthly income is sufficient to maintain your family. I work in other person house. For how many hours you were with police and whether police returned? I was with police for about 24 hours. Now next is I have explained to the accused the gist of the provision of section 164 CRPC coupled with section 281 CRPC and section 24 to 30 of IPC of Indian Evidence Act in details. Do you know what I am, that I am not an officer of police, but a magistrate? Yes, I know. So these questions are put, my lord, before giving him adequate time for reflection also. Whether any influence, promise, force, threatening was made to you, police or any other person to make? No. So voluntarily, yes, the question. Do you know that you are not bound to make a confession? Yes, I know. Do you know if you confess the accusation, it may be used as evidence against you? Yes, I know. Next page 148 is, why do you want to confess? I want to confess my guilt. So these are the question, my lord. The answer is also given. So in question number 8 also, my lord, Roman, whether police promise or assure that you will be made an approver. No, the police have not made any promise to me. Do you know that you may be convicted on your own confession? Yes, I know. I assure that you will be remanded, sent back to police even if you do not confess. Are you clear about it? Yes, I am.
এইটো confessionটো হেৰি নহয়। Next এইটো confession নহয় মানে confession mainly maximum 320 কাৰণে হ'ব পাৰে। কৰা নাই তো। Next page to 151. তার আগর পার্ট এটা একদম কারেক্ট এটা আছে এইখানে পার্ট এইখানে page 150 we had a conversation on the date of second paragraph. I killed her when she about to sleep with me in the bed. Her elder brother Jitu Bahadur came in search for her. Jitu called me and flashed his torchlight from outside. What do you say exactly? The wall of my room is made of torsion. Then when I gave a response, Jitu asked me to sleep and then left. Exactly, Jitu told me. When I asked Vimoda what would happen, she told me nothing would happen and she puja khaniya milise. Last person you would like to last person would like. He says that she had committed suicide. He had not confessed about 302. Suicide by Gamusa. How was it possible? He was with her. It was not by slitting or anything. Is it possible?
That part statement, my lord, the prosecution
Is it possible that you can kill yourself with a Gamusa?
that is
Leakage mark was found. but-
No, unless you are hanged.
Yes.
Is it possible to commit suicide by strangling yourself by a Gamusa?
Lordship, but he was very much present there.
No,
He-
no,
Yes,
suicide.
yes.
He's giving the confession,
Yes.
he's not confessing regarding 302, 300.
My lord.
He's saying that she died by committing suicide by tying a gamusa around her neck. Is it possible?
So your lordship has to correlate that statement with the evidence of the
Now,
doctor.
that is the question we're
Yes.
trying to
My
understand.
lord.
Is it possible to commit suicide by strangulating yourself by a gamusa?
that, my lord,
It's not a case of hanging.
not a hanging matter. That choking sound, it says that, but when she made some sounds of choking and her hands and feet became stiff, I shake.
Now, is it possible for a person to commit suicide by strangulating herself by a gamusa?
That is, my lord, difficult to answer, my, because
How is it possible?
not possible in that.
Had it been a case of hanging, matter
But-
would have been different. Here,
Now, my lord, thing is that the statement has been exhibited by the prosecutor. And truthful and reflection time is also given. So that is the thing, whether, my lord, how she died, my lord, that is, because there is no injury mark, my lord. In the postmortem also, there is no injury, except gamusa.
No, she says, madam says that on her neck.
One gamusa has been found.
No. On her neck, there is injury.
No, ligature from the gamusa, I think.
Where
Here,
is she?
in cross-examination,
No, where is the
PM
PM?
report.
PM.
Page
Yes.
130.
130. Page 134 is the detailed description. One gamusa is found.
No, and as 131, it's there. 131, serial number for
Yes.
external appearance.
Take horizontally
Mark
placed.
of ligature on neck, dissection, found on neck, horizontally placed.
Then that correlate with, my lord, page 134. More detailed description of injury. On postmortem examination, it is found that page 134, my lord, that a female body is decomposed, my lord.
Yes.
Decomposed means after 9 days it was decomposed.
But still then it come to 133,
One leak.
come to 133,
133.
muscle, bones and joints injury, ligature mark on the neck.
And it is stated that one gamusa is found, page 134, my lord. One gamusa is found around the neck, which is tightly tied.
Yes.
All injuries are intimate and duration of death is 8 to 10 days. So that ligature has been, definite opinion was not given, my lord. Ligature from the gamusa or from manual strangulation is not there. So definite opinion was not given by the, my lord, doctor, my lord. Exactly what is that so-called ligature mark, my lord. So there can be one more possible circumstance,
What is it?
my lord, that
Strangulation by a gamusa.
horizontally based.
You come to the opinion part. In my opinion,
In my opinion, that is due to asphyxia as a result of strangulation.
strangulation.
Strangulation, my lord, in both case of hanging also.
Hanging
No,
is
sorry, asphyxia happens both in hanging and
but
strangulation.
hanging how in a case of hanging,
No, I'm saying,
there
my
is not
lord,
even a suggestion that
Yes.
her she was found in a hanging condition.
so
And
report,
what is the ligature mark? What is the horizontal?
so the PM report is not fully conclusive that
What else do you need in a
there is
PM
a
report?
case of homicidal death.
Result of strangulation, what else is required?
In my opinion, that is due to as a result of strangulation.
Strangulation.
Strangulation, my lord, there are, my lord, three types. Definite conclusion was not given. Anyhow, your lordship will kindly see the confession statement. He has stated that gamusa was tied in her neck, and thereafter,
No, it's not that. You see, he says that she had tied the gamusa herself
Yes.
and had committed suicide.
page 151.
Last page.
Yes, page 151.
Yes.
Out of anger,
Out of anger, when I told her to die, if she intended to, she committed suicide by tying the gamusa around her neck.
Yes.
Can a person commit suicide by tying a gamusa around his or her neck?
Now, your lordship will examine, my lord, whether it was a murder, my lord, committed, because from page 150, you can kindly see the, my lord, the background that she came out from her home, staying at uncle house. He did not call. He came out to defecate, nature call. Then she came out and came to house of this.
Is this confessional statement taken into account? Is it a basis of conviction?
No.
And rightly.
But it was exhibited by them. Then the court has given judgment on the basis of extrajudicial court.
Correct.
So extrajudicial statement is something, my lord, made before many villagers.
No, that is a weak piece of evidence, no
Yes.
doubt. But is it corroborated?
Not corroborated. That is my submission.
Try to make out a case that it is not
And
corroborated.
this one more
Or
point
is there are major inconsistencies?
Yes, ma'am. And this extrajudicial statement was not recorded, my lord, over a span of time from 21/1/2016. For 9 days, it was not recorded. That your lordship will see the veracity of that witness, Vikram Setri. His statement was not recorded from the date when appellant informed.
Apart from Vikram,
Yeah.
uh,
So that could not be relied upon, my lord.
see, PW1 says that he came to know from Vikram, PW14, about the killing and burying of the body.
PW1, my lord.
PW1 has said at page 10.
Yes. Yes.
PW1 means the informant,
Informant.
Jit Bahadur.
Yes.
Jit Bahadur says that he came to know from Vikram, that is PW14,
Yes.
about the killing and burying of the body by the appellant at page 10. Okay?
So came to know, my lord, when, my lord.
No, that is what only the first witnesses
Yes,
have.
yes.
What about the others?
Extrajudicial confession 4, 5,
4,
5,
5,
7,
7,
then to 8, my lord.
8 also,
8, 10,
10.
then to 14 also, and 18.
No, 10 may not be. 10 says that
10.
Vikram told him.
Yes, yes.
10 again says Vikram told.
These are Gurkha student union, my lord.
10 says at page 23 that Vikram told that appellant had told him about the incident. But you're right, 8, 7, 5 and 4, independently they have said.
8 statement, 161 statement was not recorded. 8 PW8, my lord.
No, will it be fatal?
Lordship to 10 also. On being asked, Rishiram confessed before me and Joybir Limbu Chakragotam Jeet Bahadur Rai that he called Bimola Rai, killed her and buried in a field situated western side of the house of the accused.
Page,
Page 23,
22.
before PW 10. 1, 2, 3, 5, 6, 7, 7 line from the bottom.
As a person on being asked, he said that. I have to look into it to open it will take us all over something actually. I along with Jody so and so made search for Bimola. We suspected that accused might have taken Bimola, right? We well went to the house of the accused Vikram. Bottom Vikram what are we saying? On being asked, he said that Ms. Vikram said that accused Rishiram told him, that is Vikram, that he killed Bimola and buried the body. First information to Hiri Prapais. Vikram Prapais.
And thereafter, Your Lordship.
We returned to so and so, then we asked Rishiram on being as they confessed before me and so that he killed Bimola and then but it was us.
Then to PW 14 also, Your Lordship.
PW 14 is the first person, the friend of appellant. And his statement was not recorded for 8 to 9 days, although he know it, my lord, on 21. That is the thing.
Who?
PW 14, my lord.
Yes, Vikram.
Jaitley.
Yes. He stated that it was informed to him, my lord, in cross-examination, page 31, below, my lord, cross-examination, 4th line, my lord. 1, 2, 3, 5th line, my lord. From 21/1/2016 to 28/1/2016, I did not disclose the fact to any person. So that, my lord, relevant. After that, whatever the in between, my lord, cast them, my lord, doubt. So that reliance, whether that reliance can be placed upon that extrajudicial conflict. When he know it, my lord, from 21/1/16 to 28, he did not disclose. That is one part, my lord. Section 6 also says there has to be a continuous, spontaneous, so that, my lord,
But what about, we have just read PW 10 at page 23.
PW
10. Sanjeev.
23, my lord.
Yes, 10 says, since we are in 10, that on 21/1/2016.
Yeah.
See, Jeet Bahadur informed him over telephone on 20th that his sister was found missing, and next day, 21/1/16, he along with few of the other friends had gone for a search.
Yeah.
Thereafter, they met his friend of the appellant Vikram. Vikram already told them.
In that, my lord,
Page 23.
yes. Section 24 Evidence Act, may I read, my lord?
24, yes.
Yes. Section 24. Confession caused by inducement, threat, or promise when irrelevant in criminal proceeding. Confession made by an accused person is irrelevant in a criminal proceeding. The making of the confession appears to the court to have been caused by any inducement, threat, or promise having reference to the charge against the accused person, proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him. So my submission will be also be that. So that first is when extrajudicial confession is a weak piece of evidence unless it is corroborated by other evidence. And such confession was, which was, my lord,
See how have you answered the 313 question number 18, page
313.
61. A specific question was put to you that you had made page 61, question number 18.
Yes, I am innocent.
No, see the question.
PW10 Sanjeev Khaturia has stated in his evidence that he knows you. The incident occurred about 1 year ago. Jeet Bahadur informed him over phone on 21 that his sister was missing from the house. On the next day on 21, once he along with so-and-so went to Rauta police station, told him that you made contact with the deceased.
Last
Bimala.
line, you confessed for them that you made
You
contact with-
confessed before them that you had made contact with the deceased. But he does not know where she has gone. What you say?
No, the foundation which you are trying to bring in
Yes.
section 24, inducement. Is there any foundation?
Yes, my friend.
Where?
That
Okay, we'll come at 2 o'clock.
yes. Then the discovery is something, my lord, very, my lord, tough.
39.
Page 39, PW 19, my lord. May I read it?
Paternal uncle.
Paternal uncle. The informant is my nephew. Accused is my co-villager. This is Bimala Rai and was daughter of Om Bahadur Rai and my niece. The incident occurred about 2 years ago. The deceased was my niece, came to my house about 4 months before her death. He came to my house to appear in SLC examination. Suddenly, one day in the night, at around 10 p.m., he went out. But I came to know when the lock of the door was unbolted. When my niece did not come back, then I awoke up my nephew, Jeet Bahadur Rai, brother-in-law of the deceased.
Brother.
Brother-in-law,
It should be brother.
yes, not in. Who
This is Jeet Bahadur is the informant.
informant,
Brother.
who were sleeping in my house. Thereafter, we made search to find out my niece, but she remained traceless. As the whereabouts of my niece remained untraced, and as such, the brother-in-law of my niece informed the matter before the police. Later, police came and conducted search around our house and nearby places, and eventually found a suspect spot. Highly Lordship will note this. Discovery part. Eventually found a suspected spot where from the dead body of my niece was disinterred. So the accused was not in the police custody. It was not there, man. Police, my lord, found a suspected spot on his own, man. Found a suspected spot where from the dead body of my niece was disinterred. So there is no such discovery, madam, but leading to the discovery. Now, before the death of my niece, the accused used to come to my home now and then. Police also seized some article by seizure list so and so. Later, I came to know the accused committed murder of my niece Bimala Naik. Now, cross-examination. When my niece went out from my house, I did not see as to with whom she has gone out. I did not witness the commission of murder of my niece by the accused. Now, PW 20 is also next page. That is also important. PW 20 Vikas Thapa. May I read it? PW 20. I know the informant as well as the accused. This was also known to me. This was my co-villager. Accused, including the informant, are also my co-villager. The incident occurred about 2.5 years ago. At the material time, I came to know that Bimala Rai was found missing from her house. One day in the evening at around 5 p.m., Joybur Limbu, secretary of the Gurkha Union, who is also my co-villager, informed me over phone to keep watch on the accused Sri Rishiram Sharma of our village. Accordingly, I went to the house of the accused with another 2-3 persons and kept him close vigil so that the accused could not escape from his house. At the house of the accused, we saw many village people who had already gathered there. Then Joybu Limbu, along with some other person, came to the house of the accused, and your lordship will note, and integrated. That section 24 is saying he was in the custody of those persons and integrated without informing the police. Integrated the accused. So thereafter, the accused led the said person towards the field and showed one spot where Bimala Rai was buried after committing her murder. Then police also arrived. After that. Already it was. Then police also arrived at the spot and kept the place under guard till the morning. So next day only, my lord. In the morning, police disinterred the dead body of Bimala Rai from that spot. I also visited the place where the dead body of Bimala was disinterred. Crossed by defense. My house is a distance of 100 meters away from the house of accused, Rishiram Sharma, which is intervened by a small stream. When we reached the house of the accused, there were about 30/140 miles. Other village people gathered at his house.
30, this should be 40, not 140.
Yes.
30, 40 people.
Yes. Time was around 7 to 7:15 p.m. I did not witness the incident as to how the deceased died and who was involved in her killing. I also do not know who buried the dead body of the deceased. So that is the PW 20 method. Now, shall I continue my PW 21 method?
Just a minute. Yes.
Page 42 is PW 21. Sri Gautam Das. I know accused. I know the victim Bimala Rai. I do not know the informant Jit Bahadur Rai. The incident took place on 26/2/2016. On that day, I was at my home. On that day in the morning, I received one telephone call from police that a murder incident took place at Rauta. So I have to report at Rauta.
You had done the videograph.
Yes, only photo. Yes,
Videograph.
not
Not relevant.
not relevant. So next page is 43 PW 22, my lord. Dr. Orindam Bora, that who conducted the postmortem. On 29/1/2016, while I was working as medical and health officer at Udalguri Civil Hospital, I have performed postmortem upon the dead body of Bimala Rai, female. The dead body was identified by C. So-and-so Dilip Gogoi and Jit Bahadur Rai. On examination, I found following: external appearance decomposed, mark of ligature found so-and-so, and other scalp so-and-so are all intact, my lord. Thorax also intact. Then next phase, my lord, stomach, small intestine, all are intact. Injury is ligature mark around the neck. More detailed description is on postmortem examination, it is found that a female body is decomposed. One ligature mark is found around the neck. Face is swollen. No fracture is found. One gamusa is found around the neck, which is tightly tied. All injuries are antemortem. Duration of that is 8 to 10 days. The opinion is, in my opinion, that is due to asphyxia as a result of strangulation. Next is PW.
Because was present, he should have tried to do normal attending impression. That indicates that is an indication. It may not be case of suicide. Cannot be. No, brain will not give you the signal. It's unlike a slitting of your throat or your wrist. It will one action on it will continuous action. It is reversible man. I look at one cut is from a pistol. Mara level it will continuous pressure like that. নিজৰ গলৰ টিপি নিদি কেনে এইখানে হেঙিং কৰে কন্ট্রোল না বিয়ন্ড ইউর কন্ট্রোল
Was any injury found in the head of the appellant?
No. Injury in the appellant, that is not.
In his confession, though it's exculpatory, he had denied his involvement with the actual killing.
Actual killing.
But he said that he was also struck on the forehead by a dao, a kukri.
A kukri.
Is there any medical evidence to corroborate?
That is not in the evidence, but
he was not even examined.
Not examined
by a doctor.
Because he was after 8 to 9 days only. This thing happened, but FIR was lost.
No, that's a different angle. If he was injured on the forehead by a kukri, the normal is to go to a doctor.
Yes.
He has never said that he had gone to a doctor.
Yes.
In fact, somebody has said that we saw him. There was no injury mark. There is a statement we found somewhere.
No, the point which I am arguing a lot is that it's not a murder, my lord. Culpable homicide, not amounting to murder. Because she on her own came out from her house. She had developed a love affair. That is that.
No. To submit that, to make that submission, it has to be a legal submission.
Legal submission.
A legal submission under what ground? That is culpable homicide not amounting to murder. Under which exception?
That I'll come my lord after reading. Then Lordship, page PW 23, page 45. My name is Binoy Soharia. It's not relevant, my lord.
Who's he?
Binoy Soharia is a constable who recorded one videograph. He videographed this part of the dead body. So statement is limited to that only. So it can be skipped, my lord.
Yes, he has seized the compact disc. CD.
Yes. This one compact is regarding videograph.
Okay, not relevant.
Next is page 46, PW 24.
He has not six, one constable. He Hazarika has.
I was working as a constable and that day SK Hazarika seized on compact disc. In my presence.
In my videographer. So next is page 46, madam. PW 24 is Mridul Ali. I know the informant, victim as well as the accused person in the talk. On 26/1/2016, I accompanied the then SI Dilip Mili of Rota PS to the house of one Surya Bahadur Rai, as during that time the victim Bimala Rai was traceless. During search at the house of Surya Bahadur Rai, we recovered one mobile phone used by Bimala Rai from her bed, where Bimala Rai was staying till the date of her missing. The said mobile phone was seized by then SI Dilip Mili in my presence. Exhibit 11 is a seizure list of one Nokia mobile handset along with Aircel SIM. On that day, we also conducted search in the house of Rishi Ram Sharma and recovered and seized one mobile handset with SIM. Is the seizure list of Nokia mobile handset. So and so. Exhibit 12 is a seizure list, one compact disc. So it is seizure of mobile. So next is PW 25 is the
Was any CDR done?
ETR, my lord. In the paper book, I found at page 158, but
It is there.
exhibit 18, but that is not proof, I think, my lord, but exhibited. Page 158.
Six.
Exhibited. Exhibit 18. Not proof. The next witness is PW 25.
Here in this CDR,
Yes.
this mobile is of whom?
Mobile number of Richiram Sharma.
No, no. This is the mobile of the victim, I think. This is because he had called Rishiraj Sharma along with others.
Oh. This was using a mobile of one friend, my lord. So far I remember. Pooja.
Pooja Sharma.
Yes. Her mobile phone was found somewhere,
No, here, come to the first page, 158.
my lord.
The second number is of Rishiraj Sharma,
Yes.
Rishiram Sharma.
Yes.
No, this is not the number of, this is Pooja Rana. She is also been called
Yes.
at page 159.
Yes.
Oh, wait. Oh, she was very,
Pooja.
turn to the next page. Yes, 159. You're correct. She was using the mobile number of Pooja Rana and calling Rishi Ram
Yes.
Sharma
Yes,
in the fifth and ninth column.
yes. So that is the thing, my lord, that he wanted to elope actually, my, with this appellant. But he is, this appellant is, my lord, doing her master, graduation. And he told her that that you continue your study as per his competence. Then your lordship,
History, 19. Page 162, Saxon, 162. এখানে SMS কেটা দে টাইম চাওক আৰু ডেট চাওক 20/1 1737 পৰা SMS in SMS out এইবিলাক সব ইহঁত নাজানে ঋষিৰাম এণ্ড ফুজা ঋষিৰাম ফুজা এনেকে আছে আলটিমেটলি কল কৰিছে আপোনাৰ ইনকামিং 1750 5:50
and this 158 can be correlated with PW13 puja or deposition. Page 13. She stated that victim was using my mobile SIM. Page 30. And
So, okay. এইখিনি crucial দে 20/1 10টা বজাত দে 10টা বজাত আউটগোয়িং ইনফর্ম মাৰিছে পূজা মানে দিস ইজ আমাৰ ফোন নম্বৰ ইউজ কৰি আছে পূজা বুলি লিখিছে বোলে পূজা ৰাণাটো এই কণ্টেণ্ট আগতে আছে তাৰপিছত আকৌ এইটোত আৰু আউটগোয়িং কৰিছে 2 মিনিট পিছত তাৰপিছত এই পিছত এই ঘটনাটো হ'ল তাৰপিছত তাইক ফোন নাই আৰু তাইৰ ফোন নাই তাইলৈ ফোন কৰা নাই ইয়াক ফোন কৰিছে বিক্ৰমক সেইদিনা ৰাতি 20 তাৰিখ হৈ গ'লতো ঘটনাটো 21 তাৰিখে ৰাতিপুৱা 10 বজাত বিক্ৰমক ফোন কৰিছে আউটগোয়িং তাৰপিছত SMS কৰিছে বিক্ৰমক বিক্ৰমক কোৱা বুলি কৈছে নহয় মোক হেল্প কৰ বডিটো হেৰি কৰিব লাগে প্ৰমাণ কৰিছে নাইবা এইখিনি Exhibit 19 কৰিছে
প্রমাণ কোর্স সিডিআর প্রমাণ হয় না 16
And page 109 is a serial list that contains a SIM card number 95776. Is on 26/1/60.
it was a discussion of the page 29. Page 96, paragraph 29. CDR was proved by Dilip Milli. PW 22.
That SIM belong to my lord.
No, you said CDR was not proved. It was proved.
Acha,
Exhibit 19
exhibit.
by Dilip Milli. PW 22.
And this CDR, my lord, page 109, teaser list. SIM
No,
card
not,
belong
Dilip Milli is not 22. 20,
27, my lord.
27. 22 is the doctor.
Page 109 is the seizure list. It was seized from that witness house, Surya Bahadur Rai. That is PW 19.
That is the uncle in whose house
Right.
she was staying.
Saying, and that SIM card she was using is of Puja.
Fuza Rana.
So she called from all the. So there is no SIM card used by the victim, but using the SIM of Puja Rana. And seizure was made on 26/1. And on the same day, CDR was also prepared. And Puja Rana page 30 PW 13, he also stated, my lord. So apparently a love affair was there, my lord, that page 30. That this Rishiram Sharma, this is Bimala Rai was my classmate. The occurrence took place on the day of occurrence. Bimala Rai took my SIM card. That is. Day after she went home. And she also do not know. I have not seen how Rishiram killed Bimala Rai. Cross is hello, page 30, my lord. Cross says
30?
30, man. Puja Rani. Cross says except love affairs, all are hearsay. Page 30. Cross says except love affair, all are hearsay. I do not know as to whether police seized my SIM card. I have not seen how Rishiram killed Bimala Rai. I was not present while dead body was recovered and when accused has shown the death. So Bimala Rai was, this Puja was very close to her and was in constant touch on the day of occurrence also. So she did not spell out anything.
Okay.
So under what circumstances, my lord, this extrajudicial confession was made after a gap of 9 days? That has not been proved by the court. Under what circumstances? Because till it was known to PW14. If so, then it was not disclosed immediately. So on the basis
14
of
is Bikram.
Bikram, so that relevant fact is known, which is part of the same transaction. PW14 ought to have informed. So under what circumstances it was it was stated, my lord, after 9 days, prosecution failed to prove that.
Hmm?
Something must have been.
No, not on a surely to Nike হইছে নাইকি হইছে মানুষ হেৰি কৰিছে তাৰ ওপৰত নে সাসপেনশন এটা ভালো লাভ করে দিছে বিক্রমের ডিসক্লোজ করেছে এৰিও দিছে বিক্রমে গম পাইছে কি মই জানিছো কিন্তু মই যদি পিছত ডিসক্লোজ নকৰো নিজে মানে এটা লাষ্টত ভাবিলে কোন এডভাইটারটো ডিসক্লোজ বিক্রমে কি কইছে হেৰি চাইছে বিক্রম চাইছে 14 নহয় জানো let us read Bikram.
PW14
Yes,
and Bikram 161 statement is also here.
yes,
So may I read, my lord, PW14 first,
yes.
page 31. I know accused Rishiram Sharma. I also know informant Jeet Bahadur Rai. On 21/1/16, accused Rishiram Sharma called me over phone and requested me to come immediately to his house. I went to the house of accused. Accused offered tea and I stayed in his house for about 1 hour. He asked for my help. I asked him why he sought my help. Then he told me that he killed Bimala Rai and buried. He asked for my help to bury her properly.
Yes,
Buried her properly.
yes.
On hearing the accused, I became trembling and refused to do so and fled away from the house of accused out of fear. Well, next, I could not disclose, kindly see my, I could not disclose the matter to police because police may involve me. Then I disclosed the matter to the members of Gurkha Student Union. They did not inform the police, my lord. That is Joybur. That's why I'm referring to Gurkha Student Union. These are all student union. Joybur, Manoj Rai, Kirot Rai, Ram Chetri, Sandeep Rai, Chakra Gautam, and others. Out of that, my lord, Kirot Rai, Ram Chetri is not examined. So he was under their
Ram
custody.
Chetri has been examined, PW 18.
Oh yeah, I'm sorry, my lord. Kirot Rai is not examined.
He has named 1, 2, 3, 4, 5, 6, 7. 6 of them has been examined.
Yes,
If one is not examined, that will not be fatal.
not be fatal. I'm saying on this union, my lord, under whose custody he was here.
Okay, then please proceed.
Thereafter, the members of Gurkha Student Association took me towards the house of the accused. I did not enter into the house of the accused. The members of Gurkha Student Association entered into the house of Rishiram, and when they asked the accused, he confessed before the members of Gurkha Association. Gurkha accused confessed that he killed Bimala Rai. I was produced before the court. I made statement before the magistrate. Exhibit 10 is the statement crossed by defense. My house is situated at a distance of 20-25 kilometers from the house of the accused. I have my parents and
Just a
brother.
minute, just a minute.
মোটামুটি বলে he had helped her to bury her properly বলেছিল No, and then he told me that he killed Vimal Rai and buried. And bury Purisalo. He asked me for my help to bury her properly. He that is this was a halket one as a halket of all pussy on Puris. He married him. He said halke puta on everything halke puta. He did he ভয় বল এই ভয় খাই করে পুলিশ ওটা তো দেওয়া হল মে ইনভলভ মি দ্যাটস নট আ পুলিশ ন্যাচারাল people are into law 2160 million phone কি যদি হলে হয় যে আপনি কিন্তু ভেবেছিল যে বডি তার ঘৰত আহিছিল বা কি তাৰপিছত কোৰ্ট এইবিলাক ডিসক্লোজ নকৰে সি যেতিয়া বডি পোৱাই নাই তাৰ ঘৰত কৈছে আপুনি কৈছে ৰাতি মই ঘটনা এটা কৰি তাইক থৈ আহিছে এনেকৈ যদি আধা ফুটা হৈ যাব কিবা আনি দিয়া হয় ভালকে ফুটি দিব লাগে
Yes.
Yes, then I'll continue now. About comfort line matter cross. About 12-15 members of AGSU members went to my house on 28-1-2016. From 21-1-2016 to 28-1-2016. This is the period. I did not disclose the fact to any person. Accused did not disclose how he killed Bimala Rai and where he buried. While I accompanied the student of AGSU, I was not entered into the house of accused. I do not know what the accused stated. He do not know before the members of AGSU. It is not a fact that I have deposed falsely. Accused did not make confession before me, and I deposed for time. So you do not know, my lord, what the accused stated before the members of AGSU.
No, it is not a fact. Last line, it is not a fact that I have deposed falsely. Accused did not make confession before me. It is a suggestion which he has negated.
Yes.
In his chief, he said that he told accused, the appellant had told him that he had killed and buried, but he needs his help to bury her properly.
Yes, that was stated. But
And this was suggestion was given. He had negated this suggestion.
no, before the page 32, my lord,
Yes.
first line.
Yes.
I do not know what the accused stated before the members of
Yes, he doesn't know. He was outside.
outside.
He was outside.
And he also stated, my lord, in page 31, from bottom, my lord, third line, from 21-1-16 and 28-1, I did
Yes.
not disclose the fact to any person, and accused did not disclose how he killed Bimala Rai and where he buried.
Yes.
That is the thing.
That is not inconsistent with what he has said in chief. In the fourth line of chief,
Yes.
I asked him why he sought my help. Then he told me that he killed Bimala Rai and buried. That is the only disclosure. How he killed, where he has buried,
Disclosure only.
it is only a disclosure. Bikram's evidence seems to be consistent with all others. And the point which you are trying to harp, the 21-1 to 28-1, he did
Yes.
not disclose.
Yes.
He had not said anywhere that he had disclosed. He said that on hearing the accused, he was terrified. And he did not say to disclose the matter to anybody, to the police, because he thought that police would also involve him. 28, he disclosed to some members of the AGSU.
Under what circumstances, my lord, that is not true. Under what circumstances, my lord, all of a sudden, my lord, the this appellant had disclosed that. Because Vikram was in the custody of this Gurkha Student Union.
That was after 28.
When
On 28, this person had gone. This person, Joybir, Manoj, they had gone on 28.
yes, on 28, my lord, it is stated in pros.
Yes,
Line,
about 12, 15 members of Aju has gone to a member of
went to my house on
Oh.
28.
on 28.
So from 21 to 28, I did not disclose.
Yes.
And second thing, my lord, that non-recording of confessional statement over a period of time, my it creates a doubt, my lord.
Non-recording of whose confession? Is it necessary to have a confession in each case?
No, non-recording of the extrajudicial confession from the date of his knowledge, 28/1, 2016. These 9 days he was.
No, it is not only PW 14 before whom such extrajudicial confession has been made. There are many other witnesses before
No,
whom
the
they claim.
PW 14 only, my lord, made disclosure to the Gurkha Student Union afterward.
Now, understood,
Yes.
but that the fact that the appellant had made a confession before somebody else, there are other witnesses also.
That is subsequent after when PW 14 came to know. PW 14 only, my lord, stated to the other.
No. PW 14 might have stated, but they independently have stated. Come to PW 5.
PW 5, my lord.
Yes. PW 5, page 18.
Page 18.
Have you got?
Yes, ma'am. That
Then
is
come to the earlier PW 4 also, page 16,
page 16.
middle part. Accused told us that he strangulated the victim.
Accused told us that he strangulated him during investigation.
PW 4, PW 5. Then come to PW 7, page 20.
Accused told us that he strangulated, man.
Yes. Come to PW 7 at page 20. Accused disclosed before these people in my presence that he killed victim Bimala Rai and had buried the dead body near a bill. In the chief part. 5 lines from the bottom.
Accused disclosed before those people in my presence that
In
he
my
killed
presence.
Vimal and buried them.
PW 8 at page 21.
Accused then admitted to have killed Vimal and he led the people.
PW 10. Okay.
So may I read page 1116, 160 for statement of Joypur Limited,
Page
116,
116.
116.
Yes.
Joypur Limbu. Around 8:30 p.m. on 21/1/2016, I came to know from Jitu Rai that his younger sister Bimala Rai had been missing from around 10 p.m. on 21/2016. After coming to my house, he told me about that. I went to his house with Jitu. I questioned the other members of his family regarding the matter and came back. I also contacted my acquaintances over phone. But I could not get any information as regards her whereabouts. On 21/1/2016 itself, Jitu Rai told me in his house that about 2 years ago, a love affair developed with a youth named Rishiram Rai, who resided close to their house. When I came to know that Bimala used the SIM card of a girl by the name of Pooja Rana, I also questioned Pooja regarding this, but she said that she did not know about it. On the following day, I came to Rauta PS, taking Jitu along and lodged a missing person report. On 25/1/2016, we went to the police station. The officer in charge informed us that Bimala contacted Rishi 351 times in various ways from 7/1/2016 to 21/1/2000 over mobile. On 26/1/16, officer in charge contacted me and asked me to show Rishi's house to him, and I showed it to him. Police took Rishi away from his house. On the following day, we got Rishi released on bail from the police station. On the basis of the list of phone call exchange between Rishi and a boy by the name of Vikram on 28/1/2016, we questioned Vikram. Then only they questioned me. Then he said that about 10 a.m. on 21/1/16, Rishi called him to his house and requested him for a help. Vikram reached there at about 1 p.m. Vikram further said that Rishi had told him that he had killed Bimala Rai and that Rishi had asked him to help him in burying the dead body. It was said that out of fear, Vikram left the place. On 28th of month itself, we taking Vikram along with Rishi, went to Rishi's house. Then Rishi confessed before the public that he had killed Bimala, and that before the public, that he had killed Bimala, and that thereafter he had buried her in the paddy field located between Soy and Soap. Then, as we took him the paddy field, he showed us the place where he had buried the dead body. Thereafter, only police arrived at last around 10 a.m. On 29/1/16, that means next day, the dead body of Bimala was recovered in presence of the magistrate and the police. So everything was, my lord.
What we have just noted
Yes.
is the description by Jaibir.
Yes, ma'am.
He is PW4.
PW4.
The description which you just read in 164 statement,
Yeah.
that was recorded on 15/2/2016.
Yes.
Okay.
Yes.
And PW 14, he as the witness had deposed on 14/11/2017, almost 1 year, 8 months.
Yes.
But there is consistency. Whatever Bikram has said as a witness, it matches with what Jaibir has said immediately after the incident. Reason gap of 1 year, 8 months. গন্ডগোল একটু নেই।
Then page 128 is the PW 14/164 statement, Vikram Chetty.
128,
if I can read it. It was recorded on 15 February 2016. May I read it? I know Rishiram Sharma. He is the younger brother of my elder sister friend. Around 10 a.m. on 28/1/2016, Rishi called me over phone and asked me to come to his house by any means. I reached his house around 1 o'clock that day. Later, he called me to the road alone and told me that he had killed Bimala Rai. He asked me to help him in burying the dead body at night. Kindly sit. They're burying the dead body at night.
just a minute. 126 also. These are 164 to something. জিতে তাইৰ ঘৰত যোৱা বুলি কৈছে, জিতেও কৈছে এইটো কথা। কিন্তু বিমলা আছে নেকি, তাই কৈছে মোৰ তাত নাই। তেতিয়া যোৱাৰ পিছত তাই ইনকুইজিটিভলি ফোন কৰিছে ঋষি, আsked him whether বিমলা was, he said নাই, I also told him not to tell me about the conversation.
page 123, another statement, madam, one, Chokra Gautam,
Page,
page 123. 123, Chokra Gautam.
what do you want to show from here?
That page 124, I want to show, my lord.
Hmm.
Second para, 127, 2016, I came home, and when Rishiram was asked, he confessed that he had talked with and text her, but he said that he did not know what was done to Bimola and by whom. On 28/1/16, I came to know from Rishi phone call record history that he had also talked with a boy by the name Vikram. Therefore, some of our Gurkha Student Union members, including me, went to Vikram house. That is, they went to Vikram house. And when he was questioned, he said that Rishi had killed the girl and kept her buried in a field. On 28/1, this was happened. And police came on 29/1 to recover it.
Yes.
That is his statement. Now, PW 28 is the IO. PW 27, may I read that? PW 27, page 50.
50.
Yes. Inspector Dilip Mili. On 26/1/2016, I was posted as OC of Rauta PS. On that day, the informant Jeet Bahadur Rai at about 5 p.m. lodged an FIR to the effect that on 21/2016, at around 10 p.m., his younger sister Bimala Rai was after taking her meal, went out to answer call of nature outside his house. Even after a long gap, she did not return home. His uncle Surya Bahadur Rai came out from his house to locate her whereabouts. In spite of making search, his sister remained traceless. On the basis of this information, I recorded GG entry number so dated 26/1/16. Hence, I sent a WT message to all the police station of Assam in this regard and proceeded to place the occurrence along with my staff at number 3 Dhonsiri. In the house of the Surya Bahadur Rai, I conducted search wherefrom I seized one mobile phone from the bed of the Bimala Rai, kept under the mattress. I also inspected the place of occurrence and its surrounding area. I examined the seizure witness. Seizure witness of the place of occurrence also informed me about the missing girl Bimala Rai that the missing girl Bimala Rai had love affair with one Rishi Ram Sarma near the place of occurrence, and as such I visited his house and seized the mobile phone of Rishi Ram Sarma. After some interrogation, Rishi Ram Sarma was taken to Rauta PS. Both the seized mobile were sent to SP Udalguri for collecting the CTR of the state mobile. On 27/1/16, I analyzed call recording of both the mobiles of missing girl Bimala Rai and Rishi Ram Sarma and found that both of them were talking each other on 21/2016 at around 10:06 p.m. They also exchanged short messages service between them in the mobile phone. After that, there was no telephonic conversation between Rishiram Sharma and the victim. However, accused had received one call from so-and-so number on that day at 11:29 p.m. On the other hand, on 21/1/16 in the morning at about 10:15 a.m., Rishiram Sharma contacted with one Vikram Setri in his mobile phone and talked for about 246 seconds and also exchanged 10 number of short message service. On the basis of this frequent telephonic communication between the missing victim, Bimala Rai and Rishiram Sharma, I suspected Rishiram Sharma had been involved in the missing of Bimala Rai. On 27/1/16, I went to Tinsukia deposed before a court of additional session judge in connection with session case number so and so. So I handed over the case diary to SI Khogendra Nath Hazarika of Rauta PS for taking the needful action. Exhibit 17 is the sketch map, place of occurrence. Exhibit 17(1) is my signature. Exhibit 11 is seizure list of one mobile number and one SIM card of Aircel bearing so and so. Exhibit 11(3) is my signature. Exhibit 2 is another seizure list of one Nokia mobile handset and one Aircel SIM card bearing so and so. Exhibit 2 is my signature. Exhibit 18 is the CDR of mobile number 9 so and so containing 49 pages. Exhibit 18(1) is the CDR of incoming call from mobile number so and so to mobile number so and so at 22:06 dated 21/2016. Exhibit 19 is the CDR of mobile number so and so containing 17 pages. Exhibit 19(1) is the incoming SMS from mobile number so and so so and so. Exhibit 19(2) is outgoing call from mobile number. Exhibit 19(3) is another outgoing call from mobile number to mobile number. So these are all mobile numbers. And crossed by defense in connection with this case, formal FIR lodged on 29/1/2016. I did not arrest the accused during the course of investigation on the basis of missing information. So on 29/1/16 only my FIR was lodged. And the
So
PW7
prior to that, missing information was lost earlier
lost,
immediately.
yes, 26, my lord.
Yes.
But he was not arrested. No. Only on 29/1/16 only, when Vikram Setri when disclosed. Now, this IO, my lord, this PW27 evidence does not say of the other witnesses, my lord. The Gurkha Student Union. It's not stock of the, my lord, Gurkha Student Union has not been given in evidence by the investigating officer. Now, next is my lord PW28, page 52. SI Khogendra Hazarika. On 28/1/2016, I was acting as OC of Rauta PS due to absence of regular OC Dilip Mili, as he was on leave due to official duty. On that day, on 11:15 a.m., one Joybir Limbu informed me over telephone that the missing victim, namely Bimala Rai, as reported before the police station, had been murdered by Rishiram Sharma, as he confessed before him that after committing murder of missing victim Bimala Rai, her dead body was kept concealed underneath the earth, and Rishiram Sharma had been kept detained near the place where the dead body was kept concealed by him. On getting some information, I recorded a DD entry number so-and-so dated 20th-1/2016 and immediately rushed to the place of occurrence with my staff, which is at number 2 Dhansiri Cultivation Field, and also informed the matter to the Police Circle Inspector Rauta. At the place of occurrence, many people in the meantime have gathered, including the informant Joybu Limbu and other elderly village people. The accused Rishiram was taken into our custody immediately as the village people were trying to manhandle him. After taking the accused in my Jima, he stated that he would show the place where the dead body of the deceased Bimala Rai was buried after committing the murder. As darkness prevailed during that time, and as such on next day in the morning, in the presence of additional SP so-and-so, Executive Magistrate and CI Rauta, we disinterred the dead body by recording videograph. Exhibit 20 statements as leading to the discovery. Then the Executive Magistrate conducted inquest on the dead body of Bimala Rai. Thereafter, the dead body was sent for post-mortem examination. I recorded the statement of available witnesses, prepared and sketch map of the place of occurrence, and seized a pair of shoes. I seized the mobile phone of witness Vikram Chetri and Pooja Rana and the compact disc video disc. On conclusion of investing and having found prima facie case, I led the search sheet against the accused Rishiram under section 30220 IPC. Exhibit 4 is the seizure list of so-and-so. And these are all, my lord, exhibits. Crossed by defenses before informing me by the informant Joybu Limbu over telephone, local people had already gathered at place of occurrence where the dead body of the deceased was buried underneath the soil by the accused. So there is no such discovery, man. Already place of burial is known to the village and or to the Gurkha student. Already the place of burial is already known. So there is no such discovery, madam. And discovery and, my lord, killing, these two are distinctly different, my lord. Merely recovery of a dead body does not lead to the inference that it was killed. So basically, my lord, PW 28 says that Joybu Limbu, he only informed on 28/1. And it was before the Joybu Limbu that appellant confessed. So extrajudicial confession has to be, my lord, corroborated, my lord, by other evidence, my lord, and it has to be proved like any other piece of evidence.
No, here extrajudicial confession was made before whom? How many witnesses? Was it only one witness?
Yes.
Only one witness?
Joybu Limbu, as per PW 28, my lord, it was only Joybu Limbu, my lord.
Where?
PW 28, page 52, my lord.
52 years.
On that day, on 3rd line, on that day on 11:15 a.m., one Joybu Limbu informed me over telephone that the missing victim named Bimala Rai has reported before the police station had been murdered by Rishiram Sharma, as he confessed.
Yes, that was the version of the IO.
Before him.
Yes, Jayaguru, it was Jayaguru Limbu, one of the persons.
Yes.
Before him, such confession was made, but was it limited to only Jayaguru Limbu, Joybir Limbu?
No, it is not limited. It is been,
No, is it required that all the persons who have been informed will call the police? One has called the police.
Yes. one has called the police, but
And
the,
police said that over telephone, he said that before me, confession has been made.
the PW 20th statement, my lord, basically is confined to the recovery of the dead body, my.
Yes.
That is what he tries to say that.
No, discovery part we can, it may not be leading to discovery. As we had earlier indicated, 27 is an exception to 25.
Yes.
That the confession made before the police is not admissible in evidence. But if it leads to a discovery,
Then
then it
exception.
may be exception. But here it's not a case of leading to discovery. Body was already recovered. Why do you bring in 27? The prosecution may not need the aid of 27. When there are other independent witnesses, including for at least 5 numbers of persons, witnesses before whom, who alleges at least, that who claims that before us confession was made. Now, are their versions inconsistent? Number one, in their cross-examination, were they able to be shaken?
Before that, my lord, prosecution has to prove beyond all reasonable doubt that none other than the appellant has.
You're correct. 5 persons have said that before me, before me, before me. Are their versions inconsistent with each other?
Now that we have to see in section 24 Evidence Act, where a confession made before them was in their custody, inducement, fear.
No, that suggestion also you have not given. That you had induced it, you had threatened him. That even suggestion foundation is not there.
But I have found one statement where he was interrogated, madam. Your lordship has
Interrogation,
P19.
interrogation is questioning.
Yes.
Questioning is not any kind of a coercion or inducement. Interrogate.
Interrogated the accused. Because the Bikram Sethi, my lord, had not stated, disclosed the, had not made the extrajudicial confession before the Gurkhas could immediately on coming to known 20.
Persons interrogated accused, Thapa has said, page 40.
Yes.
PW 20.
Accused the person.
PW 20, page 40.
Score 1/4.
Have you got?
That is well regarding discovery, my lord.
No, no, your interrogation.
Yes, then Joybur Limbu along with some other person came to the house of accused
And interrogated.
and interrogated the accused.
This is the only thing.
Thereafter
Interrogation
accused
is asking questions.
left the person towards the field. Now that under what circumstances, my lord, he had appealed, that has prosecution has not proved under what
No, of
circumstances.
course, in the even a suggestion has to be there. 5 numbers of witnesses have said that before us he has confessed. Did you even put even a suggestion that no, he did not confess and you had put pressure upon him? Let them negate, that's a different matter. At least you have the foundation to build up a case.
The PW 20 says, my lord, that I did not witness the incident. As to how the deceased died, page
Oh,
41.
none has, is there any eyewitness?
No.
Then it's not a question of eyewitness, direct evidence, a case of circumstantial. And extrajudicial confession are some of the ingredients to form the chain.
Yes.
Now, if you can make out a case that those versions are not consistent with each other, one has said something else, one has said something else, then a doubt may arise. But are you able to do that?
No, my first argument will be, my lord, from 21-1 to 28-1.
That you have already said.
That I will argue, my
He has
lord.
explained, Vikram has explained. Vikram was called, he went to the house of the accused, he was offered tea, Then he said that something exception. What is it? I had killed so and so, buried her, not properly. I need your help. He became very afraid, he trembled. And he thought that if I say to the police may involve him. After 7 days, he took 7 days to inform members of the Gurkha students. That is natural.
But his statement is, my lord, whether believable.
No, that is necessary. If in the meantime there was no action taken, matter would have been different. They had gone for search for the girl, missing person report. The matter was circulated all over all the police station. Then in the meantime, they knew about some love affairs. There was some suspicion on him. He was taken. In fact, Gorkha people only they had got him out on bail. Now, when they had their suspicion became reasonable, then
My lord, my line of argument will be that extrajudicial confession is a weak piece of evidence, and in absence of any other, my lord, in absence of any other witness, my lord,
it has to be corroborated.
Then secondly, my lord, I have to argue on, my lord, whether it is murder, my 30.
300.
Yes.
Yes, please do.
And nobody has seen, my lord, deceased and the appellant are not seen together, man. Deceased and the appellant was not seen together.
No, that is not even the theory. Larsen theory is not involved.
Not there,
in this
not
case.
there.
Not there. Not there.
So from the period from 21 to 28, 116, my lord. Is that period, my lord, cast a doubt in the prosecution story, my
You said an unexplained period of 21 to 26.
Yes. Because under line of argument will be, my lord, section 6 of the res gestae method. That is also has to be seen. It's an exception to hearsay method. Relevancy of fact forming part of same transaction. So facts which so not in issue are so connected with a fact in issue has to form part of same transaction. Chain of circumstances are relevant, matter.
Yes. What is your submission?
That, my lord, has to be, my lord, immediately, my lord, spontaneous, and so that it can be, my lord,
In this case, doctrine of res gestae has been applied.
directly not applied, my lord.
Then where these are aids for the prosecution.
Yes.
These are not for the defense.
But when they are relying on
It's an
extrajudicial
as you have
confession,
rightly pointed out, it's an exception to hearsay
Yes.
that the prosecution can take aid of res gestae. So spontaneous that even if you are not seen it, heard from somebody, but it's so spontaneous that you can take into account. But how does the defense take advantage of res gestae when the doctrine itself is not applied?
that I have to, my lord, see. Yesterday I could read up to PW 10, my lord. But otherwise,
Now, we just had a cursory glance at the judgment. Res gestae, where is the application of res gestae?
yeah, I have to see. Lordship is correct. Whether that plea has been taken. So basically, my lord, I have some judgment, but I public prosecutor would like to.
No, you can place the judgment.
Lordship will take another,
No, we'll complete this. We'll
Complete.
give and hold it to you.
then I have some judgment. One is on disclosure.
Please give the citation.
2000, I have copy, my.
No, give the citation.
2009 2 GLT
2009
2 GLT
2 GLT
414.
414 name.
Rajiv Pukon and another versus State of Assam.
Okay.
Paragraph 54, man.
54.
Doctrine of confirmation by subsequent events. It is on discovery. Justice Salameswar, full bench. Paragraph 54.
See, 27, you have said it is not, it's not applicable. It's not leading to discovery.
Yeah.
So how is this relevant?
The exact,
Even they have not taken aid of 27.
exact information given by the accused, that could be proof, man, leading to the discovery. Discovery must, man, before the Kurtha student also, that has to be proved. Para 54, if I can
These
read.
witnesses have said that they have all gone to the place of, the place where the dead body was found. They had informed the police. Police came and secured the area. Next day, the body was exhumed.
Prior to that, there are some other villagers already reached the spot. Because the dead body was disinterred from an open
See,
paddy land.
see, this would be a very dangerous kind of a thing. So many witnesses have been examined.
Yeah.
Now, other villagers are also there. Is it necessary to examine all the villagers?
No, no. I'm only saying that, my lord, if I can read paragraph 54, my lord,
Of?
of this judgment, my lord.
Okay.
In Botra so-and-so reported in 2002 8 SCC 45, the court dealing with this subject observed thus, the statement which is admissible under section 27 is the one with the information leading to discovery. Under thus, what is admissible being the information, the same has to be proved and not the opinion formed on it by the police officer. In other words, the exact information given by the accused while in custody, which
So this entire day judgment of full bench is only on 27.
led
Cannot be
because
applicable.
he was
The full bench score. This is the only, what is the disclosure statement?
I-
27, why not? If prosecution has taken 27 and it was the main foundation of the case, then probably your argument would have mattered.
because he was taken into police custody on the spot. So
Yes.
police
After
said that
recovering,
the recovery.
27 is not applicable. That part you are correct. And 27, they have also not applied.
Uh, Then your lordship. Kindly, on this 27, your lordship kindly see page 103 of the judgment.
103.
Yes,
Yes, please.
page 103 of the paper book.
Yes, yes.
I'll read from the first. The
Mm.
section says, I'll read from page 102, last slide.
Mm.
It will therefore be worthwhile at the outset to have a short and swift glance at section 27.
Yes.
And be reminded of its requirements. The section says, provided that where any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to that fact hereby discovered may be proved. The expression provided that, together with the phrase, whether it amounts to a confession or not, so that the section is in the nature of an exception to preceding provisions, particularly section 25 and 26. It is not necessary in this case to consider if this section qualifies to any extent section 24 also. It will be seen that the first condition necessary for bringing this section into operation is the discovery of a fact, albeit a relevant fact, in consequence of the information received from a person accused of an offense. Second is that discovery of suspect must be deposed to. The third is
No,
that,
Mr. Borua, we're cutting it short.
yes,
The entire discussion is academic.
yes.
Where is the application?
The court has discussed the evidence of on
Where?
section
This
20.
is only academic. What is 27? How is it to be proved? You can come to page 42, the paragraph 42, last part. This perhaps you may not agree with.
Yes, the
Yeah.
paragraph 42, yes.
42, last part.
The information, it start from, it is notice,
No, 101, read from the last part.
the information given by the accused to police
In custody.
while in custody gives specific guarantee assurance that he killed Bimala Rai and buried, and accordingly police exhumed the body from the place as shown by accused. As such, it can safely be said the prosecution has been successful establishing the case. That is
That is what
one
you
of
can.
my, I missed that line because yesterday I
This
could-
is what you can argue, but
Yeah.
as we have already said, we may not agree with this
Yeah.
finding. 27 may not be applicable.
Yeah.
But we have to see other than 27, are the materials, other materials enough, sufficient to come to the same conclusion?
So Lordship, if it part heard, my lord, then I can prepare the other part for only half an hour. Next day I will take my lord. On Thursday, if your lordship, because PP will have also have to address my.
No, we'll hear PP today itself. We have 1 hour.
So that
No, you have covered all the,
only on murder 300, my lord. I will have to, my lord. Today, my lord, I have to,
300 on what? What are the points?
my lord, under some exception, whether it is a murder amounting to murder or not.
No, let us read 300.
Section 299.
Read 300. Why do you read culpable homicide?
Yes, 300. May I read it?
Yes, please.
300 murder, except in the cases herein after accepted, culpable homicide is murder. If the act by which the death is caused is done with the intention, the word intention is there, of causing death. Or secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. If it is done, thirdly, if it is done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Fourthly, if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Then next is when culpable homicide is exception. Exception 1, when culpable homicide is not murder.
This is grave and sudden provocation.
Yeah.
Not there.
Not yet.
Number 2,
Uh,
exercise of the private right of private defense of personal property. Exception 2 will not come. 3, public servant, not come. 4, in a sudden fight without premeditation, not come. 5, when he volunteers. These exceptions will not come. In fact, there is no foundation.
complete. That, on that point,
No, this,
on the,
no, we have read,
on the
read
proposal,
the facts, perhaps this exception will not, will not make, not be able to make out a case on this. You can make out a case on the basis of the evidence, nothing else.
and secondly, my lord, the punishment is on the sentence portion, my lord. Already he has completed 9 years. As on 20 years when he was a age boy of 20 years. With good academic, he has passed his SLC in first
The sentences are life.
yes, but and the language used in the judgment is life means whole of his life.
Life means life only.
Yes.
There is no,
Like it has used one word, my lord, that's right. Imprisonment more life, which means whole of his life.
that is the correct interpretation. Life means life.
So that sentence first your lordship may take into account because
No, is there any other, any other punishment prescribed under 302? If the sentence, if the conviction is maintained under 302, is there any other prescribed, any other punishment prescribed? We don't think so.
No.
What are the punishment for 302? Either death or imprisonment for life.
for life.
Unless it is converted, then it will be without jurisdiction. For murder, how can you give a sentence which is less
That
than?
Punishment for sentence portion your lordship, I leave it to your.
No, then you'll have to make a you have to interfere with the conviction under 300.
The manner in which the incident happened, my
Unless the conviction is converted, we cannot touch upon the sentence. It has to be in prescription with the law. Only two penalty, either death or life,
Right.
and along with fine.
There are some more judgment, my lord.
If you can make out a case for conversion,
Yes.
that culpable homicide not amounted to murder, then the scope of reducing the
Yes,
sentence may come.
That is. To that extent, my lord, I have not gone today, my. Otherwise, the others regarding extrajudicial.
Mr. Borua, the scope which you had, which we think you had, has to be based only on the evidence on record. It will not come under any of the exceptions. And in fact, there is no foundation for such exceptions.
So on extrajudicial confession, I have two judgment, my lord.
Yes, please.
2012, 6 SCC,
What does it say? Weak piece of evidence.
yes, and
Corroboration required.
corroboration
That
required.
is that we have already, we have accepted that. That's a universal principle. What is against you is that we find 5 numbers of extrajudicial confession, or all appears to be consistent, and not only with themselves, even statements made under 164 immediately after the incident, those also appears to be matching.
That-
And in a lapse of 1.5 years, there may be minor inconsistencies, but we find that there is no major shift. It is more or less consistent.
Part.
Okay.
Lordship, what I could gather from the submission made by the learned friend, your lordship, on the side of the appellant, there is delay in lodging the FIR, my lord, and the extrajudicial confession made to certain witnesses are not consistent.
No, delay will not accept is a delay.
Lordship.
A person goes missing,
My
he
lord,
immediately lodges a missing report.
My
You
lord.
cannot presume that he is or she is dead.
my lord.
Only
Lordship.
when you get a concrete information
My
that
lord,
the person has died, he lodges the second affair.
My lord.
There was a GED entry. There are materials on record to show that based on the GED entry, the information was given to all the police station.
Yes,
That
my
this
lord.
particular missing case.
Lordship.
So that delay is not the part which you'll have to say that Vikram's part.
Yes, my lord. So,
Is it trustworthy of taking into account?
lordship. So, but they could not cross-examine, they did not cross-examine to that effect. That there is some enmity or something like that. Why should Bikram would depose falsely before the court as regards whatever has stated before him, my lord, by the accused person, as regards the extrajudicial confession part?
No, on the part that why Vikram claims that immediately on 21st morning he was called,
Lordship.
he was told of the incident, but
My lord.
yet he did
He
not
kept-
inform
yes,
the
my
police.
lord.
Number one, he informed members of the student union after 7 days.
My lord.
Mr. Barua is trying to make out a case that it gives a lot of suspicion or doubt.
My lord.
Is it natural to keep silent for 7 days?
Let us see the evidence of
Yes,
PW
exactly,
41.
yes.
Page 31. Should I read? May I
Yes,
read?
please.
I know accused Rishiram Sharma. I also know informant Jit Bahadur Rai. On 21/16, accused Rishiram Sharma called me over phone and requested me to come immediately to his house. I went to the house of the accused. Accused offered tea and I stayed in his house for about 1 hour. He asked for my help. I asked him why he sought my help. And he told me that he killed Bimola Rai and buried. He asked for my help to bury her properly. By hearing the accused, I became trembling and refused to do so and fled away from the house of accused out of fear. I could not disclose the matter to police because police may involve me. Then I disclosed the matter to the members of the Gorkha Student Union, that is Joybir Limbo, Manoj Rai, Kirat Rai, Ram Chetri, Sanjeev Jit Rai, Chatra Gautam and others, what accused stated before me. Thereafter, the members of the Gorkha Student Association took me towards the house of the accused. I did not enter into the house of the accused. The members of Gorkha Student Association entered into the house of Rishiram, and when they asked the accused, he confessed before the members of Gorkha Association. Accused confessed that he killed Bimola Rai. I was produced before the court. I made a statement before the magistrate. Exhibit 10 is my statement. Then in defense, my lord, my house is situated at a distance of 25 kilometers from the house of the accused. I have my parents and brother. I do not know the phone number of the accused by which the accused called me. It is not a fact that I stated before the police that on being called by the accused, I went to his house with Sil Bahadur Chetri. About 12-15 numbers of AXU members went to my house on 28/1/16. From 21/1/16 to 28/1/16, I did not disclose the fact to any person. Accused did not disclose how he killed Bimola Rai and where he buried. While I accompanied a student of AXU, I was not entered into the house of the accused. I do not know what the accused stated before the members of AXU. It is not the fact that I have deposed falsely. Accused did not make confession before me, and I deposed for the interest of AXU. Lordship, I think his bare reading of his evidence sounds truthful, Your Lordship. He stated the truth. It came in the reasonable mind of a person, my lord, if he can be made as an accused person. So he, Lordship, out of fear, he did not disclose the fact to the police, my lord. And he could not be shaken in cross-examination, my lord, as regards the statement made by him in the examination chair.
Read 128,
My
page
lord,
128.
page 128. Lordship, 164 statement.
Of Bikram.
Yes. I know Rishiram Sharma. He's the younger brother of my elder sister's friend. Around 10 a.m. on 21/16, Rishi called me over phone and asked me to come to his house by any means. I reached his house around 1 o'clock that day. Later, he called me to the road alone and told me that he had killed Bimola Rai. He asked me to help him in burying the dead body at night. Hearing his words, I got very scared and then by means of a trick, I fled from there and went home. Out of fear, I did not tell anybody about it. After I had returned from there, Rishi made a phone call to me and told me not to tell anyone about the matter and threatened me that if I did otherwise, he would kill me. On 21/1/16, Jaibir and others came to our house and questioned me regarding the incident.
Yes, wait for a.
My lord.
Here, 28/1/2016,
Yeah.
Jaibir came to his house. Why? Because they got information from the police that CDR,
Yes,
he was making call to Bikram.
yes, my lord.
So they had come to
My lord,
Bikram.
my lord,
So this is consistent.
my lord.
Then I narrated the matter.
I
to them.
narrated the matter to them. They took me to the house of Rishi, but I did not
I did
enter.
not, but here also it is consistent.
Yes, my lord.
He did not enter the house of Rishi.
Lordship.
And waited on the road near the house. They
Yes.
entered Rishi's house and they later informed me Rishi confessed in it.
Lordship. So, my lord,
This appears to be
Lordship.
matching.
and they had a love affair. The accused person had a love affair with the deceased, my lord. And call details records, if your lordship kindly have a look, my lord. CDR at page 158. Next is page 159, my lord. These are the incoming calls came to Puza Rana's.
Puja is Puja Rani.
Yes,
Yes.
which is the SIM was holding
SIM.
by the deceased person. At time, your lordship will kindly see 22:04:57 hours. And 65, I think this is the number of calls, man, I'm not sure about it. 65. Last but one column,
Page.
same page 159. The call which came to Pooja Rana's same phone holding by the deceased. 65 numbers, and next one is 57. It came from-
65, this is not 65, no, this is 65 seconds, I think, or numbers.
Maybe numbers, my column is not, I may see the original. Like it's
This is not.
this odd hours, 22:04, 22:06, the phone calls came to the incoming call. Came into the phone number of the deceased finder. The phone which was holding by the deceased person.
কলম থেকে কি আছে এটা আইডিয়া আছে নাকি আপনার এইটো কাৰ পৰা কোন আহিছে এইটো ইন মানে পূজাই পাইছিলে নেকি ফোনটো নে কি নিশ্চয় কৰিছে নে পাইছিলে নেকি ফোনটো বহুখিনি গম নাপায় নাই অৰিজিনেল ৰেকৰ্ড আছে নেকি চাব নেকি ৰেকৰ্ড please see what are the on the top of the
Napi is
table.
there also in the origin.
Okay. It would key number, it was 60.
Now I take your lordship to the 164.
Man, number of calls, second the one. What is this number in the second last column? Is this
Number.
seconds?
Or maybe seems, my lord.
No.
Oh, that, oh,
1, 65, 50. These are seconds or number of calls. It cannot be number of calls. How do you make 60? And because the time is 22, 4, 57.
yes, my lord.
65 seconds, I think.
Maybe.
Duration. Next is 57 seconds.
Yes.
Because if you see on the left side, second column,
My lord.
the exact time,
22:06.
yes, it is
Yeah.
not on a particular period. It is
Gotcha.
one time.
Now I take your lordship to the
This
164.
call was made at what time?
22
10, 4.
and
10, 4, 57. Then
village
10,
lordship, village life 10-4. It's like,
no, at the same time when she had gone out.
yes, my lord.
10, 4.
Odd hours recalls the
And
big name, my lord.
thereafter.
Then I don't find.
No.
Rishi Ram,
Yes, there are.
There is no other call to her mobile. Or
Oh,
exhibit 19, my
okay. এটা কোন date হলো? দেখলাম ও করেছি। Hmm. Come to 162.
lordship, but timings are like 5:40, like that, evening hours.
Evening hours, it goes on.
Yes,
Uh,
5:40, 5:42. The
but this is
5:45.
of who, this is of whose phone number? This is of the appellant or Fuza?
The incoming outgoing is not written, madam.
বুঝিয়ে না কোন হয়, কোনে কইছে।
Maybe Rishiram to Pooja, madam, but not in,
No, these are SMS.
my lord.
SMS is out, come to the second last row.
Yes,
Incoming.
2116,
Incoming.
550
See the
incoming.
number of counts 424.
Maybe.
424 seconds.
Lordship, since maybe
Seconds,
she's not
seconds.
picking up. Oh, maybe.
Seconds.
Seconds,
It's a long call.
my lord.
And 550.
555, oh, that
550.
555 also, ma'am.
555 is no, 550 is SMS.
Oh, yeah, SMS.
Then again a call outgoing.
Outgoing at
Out-
next page 163.
Yes, outgoing 65 seconds.
Yes,
Outgoing 57 seconds. Then the matter ends.
my lord.
Then there is no call.
Yes,
Because see the timing? 10-6. 22-6
lordship, 10-6, 40 outgoing.
outgoing. Thereafter no calls.
No problem.
It was an important call actually. It was important. It was Puzan.
নিজের ফোনের উপর করছিলেন
Hmm.
মানে টেস্টিমনি আসলে I inquired.
Oh, right. Oh. Yes. Page 163. Page 163,
My lord.
you have just seen two outgoing calls by the appellant. One is at 10-4, another is 10-6. 22-4 and 22-6.
22-4, 57 seconds,
And
outgoing.
20, no, yes, outgoing.
Yes, to Pooja Rana.
Pooja, no, not to Fuza's SIM. Deceased was using.
Yes,
So Rishiram appellant had called the deceased
yes,
on quick succession.
my lord.
22-4 and 22-6.
Yes,
65 seconds, 57 seconds.
yes. That is the
Thereafter-
repetition of
Thereafter, there is a long gap of more than an hour.
my lord.
Admittedly, or presumably, the incident had happened there.
My lord.
And Pooja, in her evidence, says that when this person had gone there,
My lord.
she made a call to the appellant in
Yes.
the night. Appellant said that she is not here and do not disclose my call.
But your lordship, Pooja's SIM was holding by the deceased.
No, Pooja's own phone.
Yes, yes.
See
Yes, yes. Oh. Phone number
yes.
is different.
See, this is a
Yes.
different number.
Yes,
See her Pooja's evidence.
my lord. Pooja's evidence.
Pooja's evidence. Come to page
Pooja Rani, PW 13.
13, page 30. Page 30. And read this along with 126.
Lordship. PW 13. I know accused Rishiram Sharma. This is Bimola Rai, was my classmate. The occurrence took place on 21/16. On the day of occurrence, Bimola Rai took my SIM card. Thereafter, she went home. Since then, she did not return. Her brother came to our house and asked my mother as to whether Bimola Rai had come to our house. I know that accused and Bimola Rai
Yes,
had,
thereafter she has not said anything much.
my lord.
Since then she did not return. Come to
Lordship.
126.
Lordship.
126,
164 statement,
164.
Lordship.
That was made immediately.
My lord, I know Rishiram, he is our fellow villager who resides near our house. There, there had been a love affair between Bimola and Rishi. I know about it since Bimola was my friend. Bimola herself told me about it.
Mm.
On 21/16, Rishiras texted me in my mobile phone and asked me to bring Bimola to our house, but I did that. But I said that I would not.
I would not.
My lord.
Yes, please.
Around 11:30 p.m. on 21/16 itself, Bimola's elder brother Jit Bahadur came to our house
Yes,
and asked whether Bimola was in her house.
yes.
When I replied that she was not in her house, he left. After the departure, I made a phone call to Rishi
Yes.
and asked him whether Bimola was with him, but he replied in a negative. I also told him not to tell anyone.
Yes, see the
about
timing now.
my lord.
See the timing at 163.
1/6. Yes, your lordship, it's on
It's 11:27.
11:27.
This, around that time, just
Yes,
before that,
yes.
around that time, Jeet had come to her house asking for her sister.
My lord.
Sister was not there.
Yes,
After the departure, I made a phone call to Rishi. This is the
my lord,
phone.
my lord,
And asked him whether Bimola was there with him. He replied in a negative.
lordship.
I told him not to, I also told him not to tell anyone about my conversation with him.
Yes.
In the night of so-and-so, Chetan so-and-so.
So, lord, consistent, my lord. Now, lordship, may I take your lordship to the 164 statement of the accused person?
Nahile. It is not a substantial question. কিন্তু আমি corroborate কৰিব পাৰিম। Maybe এই সময়টো heat of the moment গোটেইখিনি কৈ দিছিলে। By that time, sufficient time has passed. তাই হেৰি কৰিলে বহুতখিনি। পাহৰিছে বা intentionally suppress কৰিছে। কিন্তু এইটো বস্তু আৰু CDR টো মিলিছে। 11:30 around CDR মিলিছে। CDR corroborate কৰিছে। আৰু এইখন 164 টো proof কৰিছে তে Exhibit 9 What do you want to show in 160 about the confession?
Confession statement, although the learned trial court did not rely upon it, lordship is still, lordship may consider that part.
Which part?
150, my lord, is 164 statement.
Yes.
I met Bimola Rai about 6 years ago. She came from Sikkim. Her father hails from our village. Bimola Rai and I were good friends. We had an affair at first, but later we broke up. Bimola often made phone call to me. If I did not call her, she got my mobile phone number recharged, thinking then I did not have talk time balance left to call her. She used to give gifts to me. We had a conversation on the day of occurrence. Around 10 p.m., she came to my room. I asked her to come inside the room. When she was about to sleep with me in the bed, her elder brother Jitu Bahadur Rai came in search of her. Jitu called me and flashed a torchlight from outside. The wall of my room is made of torja. When I gave a response, Jitu asked me to sleep and then he left. When I asked Bimola what would happen, she told me that nothing would happen and that she would tell that she was in Pooja's house. At the time, I got a phone call from Pooja and she said that Jitu had gone to her house in search of her. I got scared. I asked Bimola to leave, but Bimola did not want to leave. I took her outside so that she could go to toilet. As soon as she went out of the room, I closed the door, but she did not go away and kept knocking at the door from outside. Since I did not have any other option, I opened the door. Later, we went to a field to have a conversation. She repeatedly asked me to run away together. I did not want to elope with her. I told her that she would take HSSC examination that year, that I too had to complete my graduation, but she did not pay heed to my word. When I tried to take her forcibly to her house by holding her hand, she snatched the kukri from my hand and dealt a cut blow on me. When I tried to stop the bleeding from my head, she threatened me that she would commit suicide. Out of anger, when I told her to die, if she intended to, she committed suicide by tying the gamocha around her neck. At first, I thought that it was just her dramatic behavior, but when she made some sounds of choking and her hands and feet became stiff, I checked her chest. She died. Out of fear, I buried her under the ground. Lordship, although directly didn't come that he committed the crime, but your Lordship,
No, there is no indirect also admission that he had committed. In his
My lord.
164, he has not even said anything that he had
Lordship.
committed.
But your Lordship, the tying of gamocha, that it was a ligature.
committed.
Yes,
No, that's a different part.
my lord,
Here, if you read the per se, this
my lord.
statement, he has not confessed.
He has not confessed about his guilt. But he said that it was like on her own she has committed.
Yes.
But your Lordship, if your Lordship considers the doctor's evidence, it was of my Lordship horizontal ligature mark, which cannot be
Let us see which part-
suicidal. It
which
should
part-
be
which part-
homicidal.
Which part?
Your Lordship, doctor's evidence,
Page.
PW 22.
Page.
Lordship, may kindly have a look at the post-mortem report. It is there, your Lordship. PM report. PM page 130.
Hmm.
131, mark of ligature on neck dissection, etc.
आरंभ होने के लिए सब ठीक है ऐसे रास्ता प्लीज to measure question, at least show your injury, show that you are medically examined. To freedom also. We don't have anything.
Page 131, your Lordship.
Yes.
Serial number 4.
Or
Mark of ligature on neck dissection, etc. Found on neck horizontally placed. I have got a citation to that effect. When there is horizontal ligature mark, it cannot be suicidal. It will be homicidal, by the AI 2002 SC 1961.
19.
1961. I'm giving the para 4. The most culpable circumstance found to have been proved and accepted by courts below against the accused is that he had himself made a false report of commission of suicide by his wife and admitted in his examination under Section 212 Criminal Procedure Code that he was present in the house at the time of incident. His case was that he heard some sound in the adjoining room, and when he went inside, found his wife hanging by neck with a sari tied on the rafter of a roof of the house. He then untied the sari, brought down the dead body, first reported the matter to the villagers and then to the police. The postmortem report prepared on autopsy conducted by Dr. P.C. Jain shows that there was a ligature mark on the neck of the deceased, which was antemortem. The opinion of the doctor is clear and definite that such ligature mark of 5 cm weight in horizontal position cannot be caused by hanging, but could have been caused by strangulation. Medical evidence therefore completely falsifies the case of the appellant that on his return from the field to his house, he had found his wife hanging and thus she had committed suicide. The conduct of the accused is also not natural. When he found his wife hanging by neck, he neither raised any hue and cry nor called any villagers living nearby. He all alone brought down the dead body hanging from the roof. He thereafter did not report the matter immediately. When villagers collected, he took a plea that she had committed suicide. He also did not report the matter on his own, but as he is deposed by Dilbut Kotwal, It is on his insistence and of the Sarpanch that he reported the matter to the police. These witnesses also stated that the wife had complained in the past to the panchayat that the appellant was ill-treating her and was not proving her food. After hearing the learned counsel appearing and going through the record, we
Yes,
find
we have read.
Lordship. And the Lordship, another factor is that although the learned trial court discarded regarding the 164 statement, my lord, Lordship, there's a explanation could have been given by the accused person under section 106, under what circumstances he died. Lordship, there's nothing in 313 statement, although in Lordship, he has stated in his confessional statement, but 313, he hasn't said anything, my lord. Lordship, and regarding extrajudicial confession, how far your lordship may rely upon it, my lord? Yes, I punch out.
Yes.
AI 1973, SC 264. Para 5. Now the circumstantial evidence in the present,
Just a minute.
yes.
Para 5.
My lord.
Yes.
Now the circumstantial evidence in the present case has to be considered along with extrajudicial confession. Both the trial court and the high court have considered the circumstantial evidence to be strong and convincing enough to leave no scope for any reasonable doubt about the guilt of the appellant. We have not been able to find any flaw in the reasoning of the high court in holding the circumstantial evidence to be complete and convincing in this respect. The extrajudicial confession in this case is, in our opinion, also free from any infirmity, and no reason has been shown as to why it should not be considered as both voluntary and true. This extrajudicial confession was made by the appellant before the village pradhan, soon after he was apprehended. From its very nature, it impresses us to the spontaneous, free from suspicion, voluntary and true. The words actually used by the appellant have been reproduced so far as possible in the circumstances of the case. No doubt the appellant has denied having made his extrajudicial confession. This may be considered to amount to retraction of the confession, but a retracted extrajudicial confession can also legally form the basis of conviction, though as a matter of prudence, the courts try to look for corroboration from some independent source so as to satisfy their conscience that the confession is true. In Parilal Bhargava v. State of Rajasthan, 1963 Supplementary 1 SCR 689, this court observed, a retracted confession may form the legal basis of a conviction if the court is satisfied that it is true and was voluntarily made. But it has been held that a court shall not base a conviction on such a confession without corroboration. It is not a rule of law, but is only a rule of prudence. It cannot even be laid down as an inflexible rule of practice or prudence that under no circumstances such a conviction can be made without corroboration. For a court may, in particular case, be convinced of the absolute truth of a confession and prepared to act upon it without corroboration. But it may be laid down as a general rule to practice that it is unsafe to rely upon a confession, much less of a retracted confession, unless the court is satisfied that the retracted confession is true and voluntarily made and has been corroborated in material particulars. In the present case, the confession considered in the background of the attending circumstances clearly seems to us to be both voluntary and true, as also free from suspicion. The circumstantial evidence also complete and convincing, so as to leave no scope for any reasonable ground of the appellant's innocence. This evidence amply serves to corroborate material particulars of the confession if any corroboration were needed. We have therefore no hesitation in agreeing with the conclusion of the High Court about the appellant's guilt. The state was after guilt. So in the instant case, the other materials, the CDR, your lordship, the evidence given by Pooja, the extrajudicial confession, and Lordship, the confession statement of the accused person, although Lordship may not, part
That
by
is
part,
not a confessional
yes, my lord.
statement. He has not confessed it.
confessed it regarding the guilt is not, but regarding the tying, my lord, tying factor. I don't think this is the case for conversion, my lord. The chain is complete, your
The
lordship.
confession at best can be for 201, not for 302.
Yes,
For evidence, that part.
My lord.
killing.
yes,
But that will not have any bearing in
Lordship.
decision-making process.
my lord,
So far as 302 is concerned.
my lord.
But what about the other material? There are other materials.
Other materials, my lord, that call detailed records, that extrajudicial confession, they are consistent enough, my lord. In 164 statement also, the witnesses who have deposed before the court, that the extrajudicial confession had been made before them. So they are consistent with their statement, your lordship.
And while he admits regarding the incident so far as going out, then she had committed suicide,
my
then he had put the body.
Lordship,
Concealment, he agrees, but he introduces a story of committing suicide by a gamusa.
lordship, so.
But that horizontal is not
Yes,
matching.
my lord. So if your lordship relies on doctor's evidence, my lord, it's a horizontal ligature mark, cannot be out of
Suicide.
suicide. I think the prosecution could link the
Well,
chain,
in
my
any
lord.
case, one cannot commit suicide by a gamusa
My
without
lord.
hanging.
My lord.
Or
And he was very much there. He could
without
have
the-
prevented her, my lord.
You
His
know,
conduct,
you cannot. It's not like slitting one's throat.
my lord,
That one action matter ends
My
death.
lord.
It's a continuous pressure. You cannot give.
my lord.
It's not possible. Hanging is a different matter. It's not within your control. The moment you are hanging, it's gone. You can slit your throat, you can shoot yourself, but you cannot
Dying with Damochar.
strangulate yourself.
My lord.
It's not possible.
Lordship, my respectful submission is that your lordship will uphold the conviction.
Okay, we close this.
Here, a lot of people, it is sentence portion, my doctor, because he is considering his conduct. 20 years
The
old.
sentence, unless we we interfere with the conviction, we cannot start the sentence. It will be against the law. Law prescribes only 2 penalties for 302. It's not up to or something. It's life or death.
Pipet करते आने को पड़े, मतलब आने को ले, exception कहता है, fine.
So that is the submission only, my doctor. My submission was based on that.
Because if you look into the fine points of distinction between 299 and 300, apart from the 5 exceptions.
Yes.
Even the extent that what likelihood, in all likelihood, it is going to commit. See the definition of 299.
299.
Other than this 5 exception,
My lord.
even the definition part, you can still carve out a case, a distinction. 299,
My lord.
whoever causes death. See, homicide is there. Culpable, whoever causes death by doing an act with the intention, again, use of intention is of causing death, or with the intention of causing such bodily injuries as is likely to cause death, or with the knowledge that it is likely by such act to cause death, commits the offense of culpable homicide. And to make a culpable homicide into a murder, the section 300 has to be read.
Yeah.
That is why it is said all murders are culpable homicide, but all culpable homicide are not
Not
murder. So if you can make it a case of culpable homicide not amounting to murder, then we have a scope of converting the sentence.
He can apply for remission before the jail authorities, which is
Not the authorities.
before the
the
government.
governor.
Yes.
It's a different matter. Okay, and close code it. B. Barua, B. Bhuyan.
Although that is caused under excitement or under passion without any intent on that part.
No, see, there are only 5 exceptions. It has to fall within any of the exceptions. The first exception, provocations, grave and sudden. There is
Grave and
not a
sudden.
case of grave and sudden provocation. And the last one, sudden fight after a sudden quarrel.
Yes, yes.
The heat of the
That is not those, and others are not at all applicable. One volunteers, more than 18 years, public servant, private defense.
It was one thing, my lord, that the victim wanted to elope and he was
That
constantly,
is, cannot be a sudden provocation. Elope. Yes. You tried to introduce the story of that you were assaulted by the kukri. That was not proved at all.
that was
No medical.
No.
And kukri assault, he said that he was bleeding.
bleeding. I've seen,
At least show us the evidence that
there is
he
no
did not
evidence.
lead any evidence.
Yes. His evidence is
So
not
that
there.
part is wholly, it's not trustworthy at all. Then perhaps that 5th exception could have
Yes.
could have come. 5th, fourth, fourth.
Fourth, my lord.
Compromise is not murder if it is committed without premeditation in a sudden fight, in the heat of passion upon a sudden quarrel.
That time.
But neither fight nor quarrel, nothing. And the matter did not end there. If this story was believable, see, committed suicide. If you are not guilty, the first thing is that you have to report. You did
Yeah.
not report, rather you tried to conceal it.
That is,
Why do you conceal? Unless you are guilty.
He is making the submission that he is aged about 20 years. He has taken the life for 18-year-old girl. So lordship will have to balance, my lord, both the sides.
judgment is reserved. Publish.
Yes. Do we have time? No. We'll have to fix a date. 9 and 10. 10, where is Mr. Kolita?
This will be of conversion,
302 matter.
302.
Circumstantial evidence.
No. Like he had a fight with his mother, he gave a batam, and he later on died.
Fight means
With altercation with his mother,
altercation.
mother and son.
Altercation may not be, yesterday we were discussing, if you read the 4th exception,
Name who gives the
After, yes. Please read the fourth exception.
Culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel.
No, wait, pause here for a moment. It is committed without premeditation in a sudden fight. There has to be a fight. And what fight has to be preceded by a quarrel?
Hmm.
It is not that committed out of a quarrel. There is a difference between a fight and a quarrel. Now read the second part. In a sudden fight, in the heat of passion, upon a sudden quarrel. It starts with a quarrel, then there's to be a fight. Fight cannot be one-sided. Did he adduce any evidence he was also attacked by the mother, or it's between two parties that quarrels went on to a fight, then somebody dies? He's the aggressor here. He may not have that intention.
No, he was intoxicated also. That also came in the year. So, but that also I cannot take a defense under 85 and 80.
85, 86 is very
I cannot
clear.
take a
very
defense
clear.
on that.
Unless you are
because
administered by somebody else.
somebody else, that he has to prove.
Okay,
but-
we'll consider.
Yes, Lord.
Matter of which year? 22.
When
When day after
Lordship, as Lordship pleases, I do not have any because every day I have to come.
Day after tomorrow, Purohit? Yes, day after tomorrow. Or next 2 to 9, positive of time, next to live positive time. Karu naam likhiba na, yate likhiba. R.D. Majumdar and you are for the state complainant and then B. Bhuya, R.B. Bora. B. Bhuya, APP or R.B. complainant. List day after tomorrow. As requested,
Yeah.
list day after, list for hearing, day after tomorrow. Date Diba.
On Thursday, Lordship?
Thursday.
Fine.
And
Tip, tip.
10 to Diba, Eku naam nahi likhiba. Paucity of time did not permit the matter to be taken up today. List after 2 weeks.